24. On the backside here, the petitioner has taken one order. I file on IA for recall. May I take tomorrow?
What backside? What is the
Suppressing the facts. The petitioner has taken an order.
proving which order?
Order
Prove me what?
CRLMC 1.
You are for whom?
I am
For
for the informant in trial court.
the accused has taken an order.
Yes.
Notice was not issued.
No, not my lord.
Leak it. Monday.
CRMC 337 of 24, my lord. The matter has been compromised between the parties, my lord. Can you take on tomorrow?
Compromise.
Pardon to mention a lots of fresh admissions here.
Your Lordship, CRLMC was admitted in this court and a notice was supposed to be issued. In the meantime, the OP number 1 has changed the postal address. She has shifted. So I filed the requisite along with the new address, but they are asking for a court's order. So I'm filing a memo and I have already submitted the new address.
May I please, Your Lordship? Lordship, item number 40 may be urgent. The council is not well.
49.
40.
It is a fresh matter or
So it's under fresh admission.
notice has not yet been issued? Wait.
CBI,
Wait and mark it. We'll adjourn it, but
okay.
Pardon to make a mention, your lordship.
Obliged.
Pardon to make a mention, lordship. Item number 46, permitted to withdraw.
withdraw.
My lord.
Yes.
Item number 65. I pray next week only. I have to obtain instruction. 65.
After notice or
After notice.
where is the
Matter
other
has been
side?
compromised. Item
is the-
65.
Where is the other side?
After side, I will intimate it.
No. I will
so that's-
note it down. We'll adjourn it, but at the
Obliged.
My lord, item 60, that was yesterday that wife has reached
60.
60.
Where is that 60? 60. Leave it as 60. Yes. 60. What happened here?
In that case, compromise has been already settled, and that is an annexure 2.
Lecture 2.
Annexure 2 is the compromise which are filed by both the parties. Earlier in one DB case that has been settled.
Murthy Ranjan Chadangi
Samnishta Das.
and Mr. Das. Where is Sir Mr.
Samnishta
Das?
Das.
And where are the other accused persons?
He has informed me that he will be present.
Let them come. We'll pass it. Yes. Yes.
My lord, the bail jump case,
Yes. You are on bail?
my lord, when the 317 petition for filed by the accused person
Where
on
is
the
that?
ground,
Where is that?
my lord, page 7, my lord.
Petitioner was on bail. Bail. On 28 8 2023, he moved an application under section 317 CRPC, which was rejected and NBW was issued. Okay, NBW was issued. 2023 500 will appear on 15th. On today or 15th.
Obliged.
May I please, the lordship? It is a Belgium matter, my lord.
Yes. You are on bail.
Yes, my lord.
Date
23/2010, my lord. 2010.
23.
My lord.
Date.
Yes, my lord.
Date.
Yes, my lord. I am telling you. 23/2010.
23 2020.
10, my lord.
Okay.
NOW, my lord, 1912. NOW.
Oh,
Since
where were you?
Yes, my lord.
Where were you? Why have you not challenged this order?
earlier.
Because, my lord, the London Council in the lower court has not been intimated, so that's why, my lord. Now the police is apprehending, so that. Kindly, any condition, my lord?
appear on or before 7th.
Oblige, my lord.
And seek remedy and pay how many you are alone?
Yes, my lord.
1,000 cost.
Oblige, my lord.
Belgium matter, my lord.
Hmm.
NBW issued on 25th 11/2014. I was on bail.
2020.
2014, my lord. Running
14.
case 15.
You are on bail, huh?
I was on bail. My lord, 317 petition was represented by other person. No step was taken on his behalf. That is the warrant has been issued.
Petitioner was on bail. He moved application under 317 CRPC, which was rejected and
No,
No,
not
they have
rejected.
The co-accused person filed 370.
No,
This
no
petition
steps
not-
were
no
taken
step
on
taken.
his behalf by the advocate.
No step.
Advocate did not take any step.
you are on bail. You
I
tell
was
why
on bail. I
other
was on-
accused what they have done.
Yes, my lord.
You are on bail.
I was on
Petitioner
bail.
on bail. And on 25/11/2024, he did not appear in the court leading to issuance of NBW against him by the court below. You will appear on 14. You will appear on 15th, eh? On or before 15th and 1,000. How many of you are there? Two?
No, only one. Only one, my lord, accused.
No. Two of you.
Anand.
Satyanarayan Maji.
Yes, yes.
and-
Both were absent on that day.
Two of you are there. You don't know how many client you have.
No, I have two petitioners, my lord.
Then
Satyanarayan Maji and
1,000 each. 2014.
my lord.
1,000 each.
Yes, my lord.
May I please, your lords? A Belgium matter, my lord. The petitioner was on bail on 5/8/95 and the NBW was issued on
2001.
my lord.
Only 1 decade and some years. 7th, you have to appear. How many of you are there?
A petition is alone, but
Seven.
accused.
7th, you will have to appear. 7th of March, on or before 7th of March, seek remedy as available under law and pay 1,000.
Oblige.
Yes.
The Belgium case, my lord.
Hmm.
He was released on bail on 11/5/2012, page 21.
11/5/2012.
No, my lord, I have something to say. The date of judgment he could not appear,
Yes,
my
sir.
lord.
On that
The
date,
petitioner
petition
was
was
co-accused,
filed.
my lord. For that reason, the judgment remaining seal cover.
Yes.
One of the co-accused arrested and he has been
But
subsequently.
he was
The petitioner was on
Only,
bail.
my lord, the
When the matter was
Posted for
when the trial court fixed the matter for pronouncement of the judgment, the petitioner did not appear.
and also held guilty, my lord. Subsequent to one who was arrested, my lord. In that case, the seal cover opened, my lord. The petitioner in his absence, he was guilty, held guilty.
No,
But
no,
only
he will
to
go and
sentence,
appear.
my lord, go
He
and
will
appear,
go
my
and
lord.
appear, surrender.
My lord. Until then, my lord, it kept in abeyance.
The pronouncement. Did not appear. Therefore, warrant was issued against him. Counsel for the petitioner on instruction submits that he would be appearing, he would be surrendering to the court below on or before 7th of March and seek remedy available to him under law on his undertaking. The NBW issued by the court below on, what is the date? On 21/9/2023. He stepped in events up till 7th of March.
12th of March, sir. 12th of March.
12th of March. 7th, 12th. And you pay cost 500.
Exactly.
Yes.
May I please, your lords? My lords, petitioner was on bail by order dated 2/7/2022, that is at page 9.
1 minute. In the earlier case, what was the offense?
Hello?
What was the offense?
376.
366.
376 of the converted 376, my lord. Sentence super co-accused concerned 7 years of imprisonment. The moment he surrender, he will go to
389 benefit also you can get.
No, he will go because
Better file a fee.
no, because that person is the main accused, and that is a case of elopement. So
That's right. You may get lesser sentence also.
Only sentence you have to
And if it is less than 3 years, 389 benefit also you get.
Deal.
Yes. Better that you immediately surrender and get.
that-
Okay, sir. Yes.
May I please?
Hmm.
My lords, it is a Belgium matter and petitioner was on bail by the order dated 2/7/2022. That is at page 9. NBW issued 18/8/2023.
Eh?
18/8/2023 ରେ NBW ହେଇଛି।
NBW?
Aye.
Okay, 18/8/2023. 18/8/2023. 500.
On or before 14th March.
14. Take it 15. Why 14? Take it 15.
March.
15 there.
It's also the Belgium case. My lord, he was released on bail on 8/10/2021.
Hmm.
And the NBW has been issued on 22nd of January 2024. Because
500.
due to wrong
500.
communication.
Yes.
May I please your lordship, my lord. This is a Belgium matter. The petitioner was on bail on 10/5/2010. NBW has been issued on 2000. Lordship,
14.
28/14, yes.
14. How many of you are there?
My lord, petitioner is a laborer. He doesn't know about the law.
Only one.
Only one default.
One bit.
My lord.
15.
Okay.
15 years.
My lord.
What is the offense?
Offense, my lord. 392.
Okay.
Okay.
Yes.
May I please? It was released on bail, my lord, on 8/11/11, my lord. The fresh warrant was issued on, my lord, the page 9, 12/12, my lord, 2023, my lord.
23. 500.
Yes, lord.
500.
This is a 482 matter, my lord. Petitioner have prayed for vestment of the criminal proceedings towards the cognizance order, my lord.
Hmm.
This honorable court admitted the this case and granted a stay order.
Hmm.
And the stay order was in operation till the next date. In the meanwhile, my lord, the case has not been listed, even though the order has been passed in the 2023, my lord.
Hmm.
The trial court, after completion of 6 months, my lord, posted the case for awaiting the order of this honorable court. I submitted before the trial court that this is the position, case has not yet been listed, and till the
Hey, that's right, but have you served opposite party number 2?
my lord,
Notice. Have you served the opposite party number 2? Notice was issued. Just see.
notice, my lord, I have served, my lord. I have filed the requisites, man.
Let us see.
Tracking requisites.
AD returned from OP2 without any signature.
Sufficient. It's not appearing. Let us see. Pass over. Let us.
My lord, my lord, I have filed an IA, my lord, for the.
That's right. Let us pass over. He may come. You never know. Pass over. Hmm. That's all.
Okay.
Please, my lord. May it please, my lord. Item 12.
Gotcha.
Passover, can passover. Passover.
Item 12, they are asking for passover, okay?
One passover.
Passover, yes. 13.
Kindly passover.
Passover 13.
Then 14.
May I please, sir.
14 May, please, my lord. The matter has been amicably settled, my lord.
Settle.
Amicably settled, and my lord, my learned senior is appearing for the informant.
Where are the
My lord,
parties?
that
Although party unable to appear before some personal difficulties.
When do you want?
Or any other date.
Friday?
my lord, first week of March, your lordship may post.
First week.
Any date may be fixed, my lord, so that it gets convenient.
Fifth, sir.
5th. Obliged, my lord.
Yes.
15.
Item 15, passover, my lord.
Passover.
16.
Passover.
Item 17.
May I please, your lordship?
Yes.
This is the case of 482. In this CLMC, petitioner challenged the ordinance order dated 2010-2021.
One CC number is 3710 from 21. A marriage has been both the parties have been dissolved under section 13(1).
Speak little louder.
Madam?
Speak little louder.
In this CRLMC, the petitioner.
What do you want? You have challenged the cognizance order.
Passing of the cognizance.
You have settled the matter.
Yes, my lord.
The parties have settled the matter.
Yes.
Then I issue notice to opposite party. The counsel for the petitioner, in the present petition, petitioner has challenged the.
May I pray one thing? Another matter is 4692, which is adjourned to 5th of March, connecting matter.
I'll just give 5th March. Okay.
Okay.
Note down the number. In the present petition, petitioner is assailing the order dated 28/10/2021. Passed by JMFC Cognizance Bhubaneswar in ICC case number 3710 of 2021.
My lord.
The learned counsel for the petitioner submits that the parties have arrived at a settlement out of court. Issue notice to the opposite party number 2. Opposite party number 2. Mr. Ravada appears for the state and waves notice for the state. Mr. Learned counsel will further submit that a connected matter being
4692 of 2023.
CRLMC 4692
of 2023.
or 23 is coming up for hearing on 5th of March, and the same may be the present matter may also be listed on that day. Adjourned to 5th. Yes.
Yes, Lord. As per the direction of the Honorable Court, I am filing the entire order.
What is this? What do you want?
Passing of the cognizance order.
Okay.
Lordship, in this
File
case,
it, place it on record. Then counsel for petitioners seeks the leave of this court to file the additional document to substantiate this case. He may do so or during the course of the day, leave the matter on 5th, 6th. You file it during the course of the day. 6th. File it during the course of the day. You file it in the counter.
Okay.
You file it in the counter. Yes. Next. Yes. Possible. Yes.
2122 arising out of a complaint case, my lord. This is also year-old case. In the year of 2002 because of occurrence. In the meantime, matter settled and they are on peaceful manner in their village. My humble prayer, your lordship, may direct to my lord and friend for the state to take instruction from the local police, whether in these petitioners entire villagers are the petitioners, my lord.
How many of you are there?
In three petitioners more than first petition,
16.
then second, then third, my lord. In the meantime, also Mr. Mahapatra appeared and entered into appearance on behalf of the complainant, my lord. But he's on the way.
Yes.
Thrice they have taken to get them appear before your lordships.
No.
Thrice. Nai no kuhantuni unnecessarily katha kuhantuni. ଆପଣ 3 times ନେଇଛନ୍ତି ଆପଣ ମୁଁ କୋଅପରେଟ କରିଛି ଆପଣ ଲୋକଙ୍କୁ ପ୍ରେଜେଣ୍ଟ କରିବେ ବୋଲି କହିଛନ୍ତି ବଟ ଆପଣ ପ୍ରେଜେଣ୍ଟ କରିନାହାନ୍ତି ଆଜି ମତେ କହୁଛନ୍ତି ଇନଷ୍ଟ୍ରକ୍ସନ ଆଣିବା ପାଇଁ
in same case another case entire villagers is because they are sorry my lord they are residing in a very remote village of the Ranpur in the district of Nayagarh. They are vulnerable poor, my lord, poor.
All right, where is the affidavit? You have not filed affidavit.
Joint affidavit
or something you have to place on record.
Joint, we'll make joint affidavit.
Joint affidavit file karantu.
File the joint affidavit, go before the IO and be present there, and the IO will give the report.
Yes.
Obliged, my lord. Obliged, my
In
lord.
all the 3 matters.
Obliged, my lord, accordingly.
In all the 3 matters, write down the Learned Counsel for the petitioner submits that the parties in all the three matters have settled their dispute amicably. And yeah, 20, 21 and 22.
My lord,
Item number 20, 21 and 22.
my lord, my lord.
Yes, yes.
They will appear before the IO and
In all the three cases, the entire village involved in the case. Therefore, it would be practically not possible for him to make all the not possible to make the petitioners appear before this court. Therefore, he submits that he would be filing a joint affidavit of the parties and all the petitioner that is the villagers would appear before the IO of the case on 26th of
26th, yes.
26th of March 2024. The IO of the case is the IO oblique IIT.
Yes, yes.
Which
Chandpur police station. Chandapur
police station. We directed to verify the facts, and furnish instructions to Mr. Maharaj, the council appearing for the state by next date appearing.
Sorry, my lord, 26th February, my lord.
February. Yes.
My lord, 26th February.
That's what I said.
Obliged.
26th February.
Leaves the matter on 28th.
Yes.
My lord.
Joint affidavit city se file kariye.
Joint affidavit you file,
My lord.
and the IO will verify, give instruction, then we will.
My lord.
Huh? 28th. 28th. If you don't do all these things, on the next date appearing, all the three matters will be dismissed with call.
My lord.
Be ready with that.
My lord.
Huh? I'll let them wait for another. Yes. 20.
May I please your lordship? My lord, the
may
present
be
petitioner
pardoned.
has filed one application before the Law and
Item
Court below.
19 Miller,
That is, my lord, annexer 3 is my 311 petition, my lord. And in Law and Court below, my lord, I have filed to recall the PW2, my lord. Some essential question may kindly be put, my lord. Annexer 3 is my petition, my lord.
Who is PW?
PW2 is my lord, doctor, my lord. Dr. Sanjeev Kumar Behera, my lord.
Where is his testimony?
Pardon?
Where is his testimony? Where is his statement before court?
The statement, my lord, as per the charge sheet, my lord.
Not charge sheet.
Statement, my lord, 161.
In the court. In the court statement. In the court, is he a deposed?
My lord.
You are asking for recalling of a witness.
My lord.
What has he said in the court? Let us see.
My lord.
Why have you not cross-examined him?
My lord, in the rejection order, my lord, page 28, it is reveals that it is submitted by the defense counsel that during course of examination of the witnesses, PW number 1 to 8, he had left certain questions which are necessary to be put to the witnesses. And counsel has also furnished as many as 20 number of questionnaires along with his petition, and he wants to put such relevant questions to all the witnesses, my lord. On the special PP filing written objection that vehemently object to the prayer of the defense counsel, it is submitted that defense counsel has not specified the questions as to which question he wants to put.
Okay, what is the offense?
My lord, the offense is under section
323.
My lord, 341, 294.
B, 3 HST and
My
other
lord.
offenses.
Give one opportunity.
Yes, sir.
One opportunity.
Yes, sir.
My lord.
The application of the petitioner under section 311. Petitioner of 311 has been rejected by the court below by the impugn order dated 21/8/2023. The petitioner being the accused in FIR number so and so seeks to recall the PW. Which PW?
PW2, my lord.
8 got a dispute. PW 1 to 8 total. First, First to last, all.
No, Kali doctor.
Kali se
PW1.
Se khali
PW, which PW you are talking about?
My lord, as per my petition, my lord,
Not your petition. What do you want?
my lord, PW 2 Sanjeev Kumar Behra, doctor.
Setik to?
PW2. What is it?
PW1 to 8.
My lord, pardon, my lord. As per my petition, my lord, I have stated that
You don't know about your own case.
the PW1 was not examined. That whether PW1 to 8, my lord, I have filed.
You said you argued for PW2. Now
No, PW2, but regarding my lord, my petition, it reveals that.
No, it can't be retrial again. Not in
Ye
your
kar
case.
retrial haba outre.
You decide. If you want to call one doctor, I can give one opportunity.
Yes.
Not that you can't.
All.
Retrial once again. In a 323 case, you want to waste time of court. Only doctor.
Only doctor,
You argued, you started
my
with
lord,
that argument.
my lord.
Now he pointed out, otherwise I would have passed your order. You don't know your case.
Pardon, my lord.
If you would not have pointed out, the
No,
order
my
would
lord,
have passed.
my lord is senior cooperate.
He is arguing your case.
No, my lord, he is my senior elder brother.
You don't know which witness you want to be called. You said PW.
No, my petition has stated.
Petition maybe.
Oh, my lord.
To kaun hai sahi gote.
As per your lordship, my lord, any cost.
Why? No.
Some vital question is.
No retrial, maybe white. You can't recall all the witnesses.
समस्त क्यों डका है? Is it possible?
My lord, one passover, I just. One passover. One. One passover.
See, sometimes you are making them wiser.
My lord.
भूल है इसमें सब भूल है जो किसी तरह.
He is asking for one witness. Now he says that 8 witnesses.
And the London magistrate will see the when will peruse the judicial order passed by your lordships, and he will.
No, I would have
it is for him to.
I would have reproduced that order.
That is why I am here to rectify. But he is not able to place the matter properly.
Yes.
Pass out.
Keep it. I'll give the same out. 24. Yes.
Allegation against me mailers under section 137, 148, 448, 294, 307, 426, 33, 353, 333, 149, read with PDPP Act, section 3. It relates to matters issue of 2006. The kind of a glance to page, FIR that
you are
kind of a page 10.
Manindra Ratha.
Manindra Ratha, case kind of a glance to page 10.
10.
Yes. Okay, fair. Name Rajiv Ranjiv Farida, Jitu Pagal, Chittaranjan Behra, Rohit.
That is FIR.
Yeah, FIR.
Come to the charge sheet.
30 others and MLA Kendrapad. So
Come
then
to the charge sheet.
Charge sheet is, then in charge sheet my name comes, but I have enclosed all the particulars and documents. None of the vital witnesses stated anything against me, but I didn't also know that such proceeding is there. I have been so abscond all throughout my I'm a cultivator.
The cognizance says the court has to see every witness and everything.
That's correct, but now question is that NVW. Now police is in search of me. Then I came to know about all these happenings.
I'll say the NVW, you go and appear with the court.
I will appear before the court.
Remedy available to you on.
I am here.
But because 307 is there.
I am here to your lordship cooperate with my learned senior and your lordship. And it's a case of passing. Lordship may issue notice and I will get the CD because my learned senior does not know. Two of the accused person are in respect of that. The application has already been quashed. There is no private materials.
It has been quashed.
Sir.
That is there.
So your lordship may kindly
issue notice to
quite well, Sam.
Where is that? No opposite party.
What topic?
The issue notice retail.
I read him. 2006 mailers.
Why can't you quash it? Why you need notice? I'll quash it.
Because I have to verify the actually say fact out. Come
tomorrow. I'll quash it.
CD
So total evidence of my 161.
Friday Achantu watch karda.
हाँ, सेटा
161 minutes I have given.
Okay, you supply all these things.
We have given that.
Let it be on Friday while
तारे
court.
Yes, ma'am.
12 खंड अछन त आपण मात्र 4 रे दैछन्ती आउ 7 अछि सेही
आपण जा अछि दे दियंतु Friday लगे दे watch करबा काम खत्म.
All fair my lord. Till then no course step my lord. The police is about
Friday I am putting it to court.
Friday my lord, Friday. No, I don't. Police every day.
Issue notice to the opposite party. Mr. Maharaja accept notice.
Yes.
He submit that ये दे दो.
सेटा दे देन
I'll pay the proceeding only. I'll not know court action.
Yes, yes.
Mr. Mr. Mahapatra, letter counsel for the petitioner submits that insofar as the co-accused persons in the present case are concerned, the coordinate bench, while entertaining their petition under 482 CRPC in CRLMC number so by has quashed the entire prosecution. How many co-accused? 2 co.
So now I'm one.
This is one. The other co-accused.
I would your lordship is holding 19
Utkal Keshari main person MLA.
I would tather mention tather yes your lordship kindly say I have seen the order is not with me see there would mention it CRLMC 1 4 something
taking into consideration, Mr. Maharaja seeks a short adjournment to seek instructions regarding the present case and to verify the allegation.
Whether the petitioner stand on similar footing
against the present.
Lordship may kindly say whether the petitioner stand on similar footing with the other accused person
and to obtain instruction regarding the parity. Regarding the parity.
Copy se jo bail order.
Please the matter on 29th. आपको this. 29th ना?
Yes.
नहीं 26th or 27th. 26th.
26th.
Let it be 26th.
26th.
26.
In the meantime, the proceeding before so states.
Premiers, I'll take that copy. I'll give a photocopy.
No, you take it. Proceeding state.
No.
Okay.
What copy to do?
May I please? Parents-in-law are before your lordship for quashing of proceeding. On the ground that in this particular case, the husband was facing trial and he has been acquitted due to the entire evidence I have filed also in judgment. All the prosecution witnesses did not support the case of the prosecution. That is why
What do you want? This is the mother-in-law, father-in-law.
Yes, ma'am.
The husband faced the trial.
Huh.
Got acquitted.
Got acquitted.
And why these people were absconding or what?
Not absconding.
Then why the same FIR? Why these people are? Where is the? Let us see. Charge sheet. Just see the charge sheet. What about you?
Charge sheet.
What is your name?
In charge sheet they are shown. Charge sheet has page 1324.
Page 24. Relevance is page 24.
No. Just see whether these people were shown absconded or what.
Absconded.
In the charge sheet.
They have been shown absconded.
Shown as absconded.
Yes.
Then?
Yes, ma'am.
Okay. In any way, what is the offense?
Offense.
498 and all.
498, 304.
Pass it.
Yes.
Pass it. 400 mother-in-law, father-in-law, husband is acquitted. Why?
Yes.
Husband acquitted?
Yes, that's what he says.
The entire evidence I have also annexed.
Where is the judgment?
Judgment at Annexure 3 at page 25 to 36.
Yes.
And the copy of the evidences Annexure 4. Not a single witness of rather they have said that deceased was staying in our in-laws house happily while she was preparing. रोषेई कला बेले caught fire.
लिखो जी. At the instance of the opposite party number 2. Karunakar Swami
He is the informant, father of the deceased.
and the girl has died.
Government.
At the instance of Karunakar Swami, the FIR number so and so came to be registered against the petition. The opposite party number 2. Notice issue in na?
Na.
Notice issue kore apne ex party I can't pass. Ex party I can't pass, sir.
Notice ka jao.
Yes, notice jao.
Okay.
His evidence is at annexure 4.
Yeah, call petitioners are the in-laws of the daughter of opposite party number 2. Daughter of opposite party. Let the counsel of the petitioner submits that the insofar as the husband of the daughter of opposite party number 2 is concerned, he also faced the faced the trial, and by judgment dated what is that judgment?
26/11/2022. 26/11/2022.
Yes, 26/11/2022. The 86 instances Judge Jajpur in city case bracket session number 46 of 2022 has been pleased to acute the husband. The petitioner being the in-laws of the daughter of the opposite party number 2 seek parity. Therefore, indulgence of this court is sought for. Issue notice to opposite party number 2. Returnable first week is so. In the meantime, proceeding before so. Stay. I stayed the proceeding. I stayed the proceeding, filed the with quasi. Okay.
Item 26, I pray for a passover of 2 matters. My learned senior Mr. Gautam Mishra is
May one more. Can we keep it to Monday? Because I asked some officials for some other discussions. Let's keep it to Monday. Monday or Tuesday, whatever convenient, my lord.
Let it be on 29th.
29th. Yes, okay, fine. Much obliged. We file the appearance. Let's reflect our name in cause list.
Why the name is not reflecting?
Only Bhukta, my name is there. Mr. Bhukta name may be recorded along with this. It a pani each a party of PRH. Wrongly related pani.
Pani.
Pari of PRH.
So there are interim orders not to go against the director, the petitioner. They may be continued.
No, my lord. Whatever order is.
Interim order to continue, maybe. But you have to seek instruction. You have to appear.
Yes,
you already sorted.
Either this court or any court, you have to appear.
You're only on
Indian authorities are investigating, and you have to come and appear.
Yes.
No ego issue here.
There is very plain.
Only thing is we can accommodate when you can come.
Exactly. Yes.
One day here, there, that one can think of.
Yes.
But you can't say that I'll not come at all. You have to come.
No. May I premier item 60, the matrimonial dispute yesterday, Lordship heard this matter. Boy is in BC mode, girl is present.
16.
60.
60, okay, we'll take it up.
Both the councils are present.
Okay, 60. I'm quashing it and go and appear. The
138, 135.
That was all. Actually, all are billable, but say nahi simti case kichi pending. That was my point.
He got the very
that 157 is pending.
Yes.
Yes. Pending against you.
Before second action session,
150. That number is correct. What my learned.
Yeah, it's number 157 for 2017.
157 of 2017.
No such record.
Case ta amo pakar no. A case ta hoche
No, that
second action session to Bhubaneswar.
Yes.
Only because the person staying in that cutoff, so that is why the MPW issued to Madhupatna PS to execute.
But no such TR case is pending so far as I have inquired.
Right.
No.
The matter was taken up for hearing on 11/1/2024 and following order was passed. Pursuant to the aforementioned order, Mr. Maharaj sought instruction and on verification he states that TR case number 157 of 2017 is pending against the petitioner.
Pending for the second extra session judge Bhubaneswar.
Bhubaneswar under section
135 of Electricity Act.
135 Electricity Act. Full sir, but due to non-appearance by the petitioner in the aforementioned proceeding, NBW has been issued. Counsel for the petitioner on instruction submits that his client, her client, would be appearing before the court below on or before 15th of March and seek remedy available to whom under law. On the basis of the aforementioned facts and the submission made it was the NBW issued by the which course? And it's
Second extra session judge Bhubaneswar.
Issued by secondary so in TR case number 157 of 2017 is quashed. Go ahead. Just it is a small offense, you can go and immediately.
But actually, no notice, nothing.
What you verified, you and the indulgence of the High Court, you have got
Obliged.
That is the reason I am not imposing cost. The cost will be more than the penalty.
किछि भी notice नहीं किछि नहीं. What my
एबे तो हिच ना अपन जान ले तो.
आगे.
I have quashed it. You can go.
Obliged.
28. Wait, please. Now I am audible, Your Lordship.
Yes.
Yes, Your Lordship, this is matter. Petitioner challenging the order dated 4 January 2024, hearing he praying for default bail in absence of the C report, Your Lordship. That matter, all the matters posted for today, man.
All the matters are posted today.
No.
Group matter.
Your Lordship, last occasion on 31/2024, the petitioner was directed to produce the application whether it has been filed under section 167(2) or not. But it's a bail application. As it appears from the order of the learned trial court, it's a bail application. It's not a 167(2). So that is to satisfy my friend by producing the application whether it is a...
Where is that order?
Yes. Your Lordship may kindly see order dated.
Yes.
41 page number 4.
Yes. Page number 41. 41.
Order.
My lord, page number 41, order dated 4/1/2024. Lordship got it?
Please read it.
The bail application dated. Lordship, the sentence starts. The bail application.
1 minute.
My lord.
41, huh?
My lord.
Okay. The bail application.
The bail application dated 22/12/2020 filed on behalf of the accused petitioner, namely Manoj Kumar, is put up for hearing. So this bail application has been disposed of. So it is to be filed by under section 413 before the higher forum. Before the higher forum means before this honorable court. So 482 praying for release on bail under section 482, it's not. That is why he was directed to produce whether the application was filed under section 167(2) or not. That application.
Have you moved any application under 167(2)?
Yes, my lord. The petitioner already filed the application under 167 subsection 2 of the CRPC. Basing on that application also, only the not comes out, my lord. You'll also come to the para 3 of page 41.
Okay,
The learned counsel accused submitted the IO are submitted final PR without any chemical examination. That is only the plea before the application moved before the learned court below your office.
I said that no dispute regarding that.
But what Mr. Maharaja is saying, have you moved an application on 167?
Exactly.
Yes,
saying that it is not the charge sheet in the eyes of law.
Right.
So therefore, I am entitled to the benefit of 167(2).
Default bail.
Okay. I
That's
filed the application before the learned court below and also applied for certified copy of that application also.
Where is that?
I have not obtained the certified copy, my lord. I have the simple copy, office copy I have.
Okay, you get it and file. We'll
My
see.
lord.
Okay.
Yes.
When do you want?
5 days after.
Huh?
5 days after.
5 days. You first week. First week. Sixth.
Grateful, my lord.
Yes. 29.
May I please, my lord?
Yes.
My lord, the petitioner is seeking a direction quashing the congruence order dated 6/9/2022 in city case number 338 of
Yes,
20.
tell me what is your case? 498. Have you
My
settled the matter?
lord, both
I am appearing for opposite note to the informant, my lord. Now they are staying happily and jointly and happily, my lord. Both are present also here, my lord. Your lordship's present.
You are settled?
My lord.
Yes, my lord.
They are there?
Yes, my lord.
Call them.
2023 at about 3:14 p.m., which violates the constitutional right of the accused and he was illegally detained for more than 24 hours.
Hmm.
And in para 8, while rejecting the order, the order reflects that in the present case, the medical examination report of the accused reflects that the date and time of examination is 27/12/2023 at 3:10 a.m. and there are no signs of external injury found in the accused. This court 3:10 p.m. my lord. This court find from the case record that the accused was not illegally detained in the PS and was produced before the court within 24 hours from the date of his arrest, and this court lacks jurisdiction to try the alias offense, that is section 37.
If this is the finding of fact, how will you get out of it?
My lord, as per the forwarding report, the petitioner was arrested on date 27/12/2023 at 2 p.m. and the arrest memo was prepared
26/12/2023 at 2:10 p.m.
My lord, 2 p.m. he was arrested and the arrest memo was prepared 2:10 p.m.
Where is that arrest memo?
My lord, page number 29, madam.
29 arrest memo.
Sorry, my lord, page number 26, annexure 3. First
Okay,
page.
arrest memo. Let us see. Time and preparation of arrest memo 26/12/2023 at 2:10 p.m. Okay. When he was produced, where is the production? When he was produced?
My lord, page number 21 may kindly peruse.
21. Okay.
29, madam. 29.
29.
29. Okay.
He was medically examined on 27 December 2023 at about 3:11:40.
First he was produced, thereafter medical examined, or medically examined, thereafter produced?
Medically examined, thereafter produced before the learning.
How will I get? Where from I will get it? Where from I will get it that he was produced at what time? On 27th.
May I, Lord, help? Lord, the arrest was 26/12.
No, wait, she's young
Yes.
girl. Let us.
Yes.
I got it, but.
Yes. Right.
Yes, tell me.
My lord, as per the forwarding report, I arrested him on date 26/12/2023 at about 2 p.m. Observing all the formalities of arrest rule, I also sent the accused for medical.
Show me from the record when he was produced in the court.
My lord, the time was not there. Only I forwarded the accused person to your honor's court, that is on 27/12/2023 through proper escort with prayer to remand him into intermediate jail custody for a period of 15 days. Only in the forwarding report last time.
Forwarding report, where is that? Yes.
Page number 60.
27.
Page
Page number 17. 16 is the first page, 17 is the last.
17.
Yes, ma'am.
Okay. You read it out.
My lord, is prima facie evidence under section 376, 294, 506 IPC, section 67, 67A, 67E IT Act were well made out against the accused Gunu alias Sarosh Kumar Sahu. I arrested him on dated 26/12/2023 at 2 p.m. observing all the formalities of the arrest rule. I also sent the accused for medical examination as per section 53A CRPC with the requisition. I forwarded the accused person to your honor's court today, that is on 27/12/2023, through the proper escort with prayer to remand him into immediate jail custody for a period of 15 days, by which date the FF is likely to be submitted.
So this is on 27th. 26, he was arrested, and 27th he was produced.
Yes, my lord. But he was medical.
26th at 2 p.m. he was arrested, and next day he was produced. What is the how you are saying that it is beyond 24 hours?
My lord, he was medically examined on at about 3:11 p.m., which is more than 24 hours.
A matter of a few minutes here and there.
My lord, 1 hour.
Yes, 1 minute.
I am for the information. After today, I will have to do his medicine also.
What is
Excluding the joining from the police station to the court, thereafter it's obviously there is right time, no exceeding 24 hours.
matter of only few minutes here and there.
My lord, from Chandipur PS to Baleshwar JMFC Rural Court, the distance is only 10 to 15 minutes.
किंतु जो रस होची सेठी,
And you have to wait. There is traffic. There are you go take the hospital. Hospital also the doctor may not be there.
Yes.
Sometime here and there. I can understand if 1 day, 2 day delay.
Yes, yes,
It is a
that-
matter of just
few minutes. Few minutes.
Strictly, if you calculate, it is only about 45 minutes to 50 minutes difference.
Difference.
For that, why unnecessary you are, I don't find any illegality in the order passed by the court below.
My lord, as per section 167 1 CRPC, it clearly says that when investigation cannot be completed within 24 hours, the accused will be produced before the nearest.
Right, there is no quarrel insofar as your legal proposition is concerned. There is no quarrel. You are absolutely correct. I am not on that. But there is no, as such, there is no delay. You simply withdraw it. Why are you inviting this thing? You have done well, withdraw it.
My lord, they may produce the accused before 2:10 p.m. on dated 27/12/2023.
But yes, they produce it. Produce him, no problem. You withdraw it, okay? Okay. Yes. After arguing at length, seeks to withdraw the petition. The petition is disposed of as withdrawn.
Yes.
I am not saying dismissed, disposed of withdrawn, because you have argued well. Okay.
Madam,
Yes.
I have filed
He is withdrawing why unnecessary? Yes.
Madam.
किसी दरकार नहीं आपको.
Yes. Yes. I just
Hey, yeah.
What is this matter? Lot of item 31. Take it up. Item 30.
Yes. Yes.
That's all.
Rest 6 cases are pending.
What is this order? 1/8/2022?
By the Annex 1,
Yes, what has happened?
the case is, I required permission to apply to the passport authority for grant of passport for visiting California and USA for a period of 2 months to see my only daughter and her family. But my petition is rejected by the court below. Therefore,
How many cases you have?
in this application, 7 cases are pending. Out of 7, 1 has been allowed by Honorable High Court by CRLMC 27-25-22 by the Annexure 2.
Yes.
The rest 6 cases are pending. So unless all the cases are permitted, I cannot apply to the passport authority for a grant of passport.
Is there any flight risk?
So order reveals that there is flight risk. Thing is that petitioner himself is an accused in 10 number of cases in the case of a bank fraud. So and this honorable court has time and again granted liberty since 2017.
He has gone and came back also.
No, he has not availed that benefit. 17 ଦେଇଥିଲେ ତାପରେ 22 ରେ ମଧ୍ୟ ଦେଲେ ତାପରେ he has not availed that.
Why are you asking for permission? You are not going.
My lord, unless all the permission I
That's
obtained.
the problem. In one case he might be getting, in the other case he will.
ତାପରେ ସେ ନିଜେ ବି conduct କରୁଛନ୍ତି case.
My
And
lord,
charge is yet to be framed. Our accused persons, due to non-appearance of accused persons, the trial court is unable to frame the charge.
in the meantime, all the cases has been charged except 2. Those are pending for hearing of discharge petition. Within 1 month, that will
But
be.
you have 10 cases. They say that you have a flight risk. Where is the affidavit? Have you filed that affidavit saying that there is a flight
My
risk?
lord,
Where
in
is-
all cases, I have been allowed to go.
In all
I'm-
cases.
Around out of 10 cases, 5-6 cases I have been already permitted by Honorable High Court.
5-6 cases, 6 na 7 aji file
Give a
करते
chart then. We will just see that. Give a chart. In how many cases you have been allowed?
Earlier, this honorable court granted him
Yes,
to
yes.
allow him to go with conditions. With that
With
condition,
conditions
with that
only,
conditions, your lordship may consider for 2 months.
But give a chart.
Ah.
Come tomorrow
Mm.
with a chart. In how many cases the High Court is allowed, in how many cases not allowed. Prepare a chart and accordingly we will pass the order.
With case
Come with the
number.
chart. So don't keep this kind of paper and get all the orders and along with a chart. Almost in all the cases you have got, barring 1 or 2 cases. But you have filed here how many cases now?
ବର୍ତ୍ତମାନ
I have applied for 6.
1,
ବର୍ତ୍ତମାନ
2,
6ଟା
3,
Chota cases.
4, 5, 6 cases.
6 cases.
You have 10 cases against you.
Total is 12.
12
Out-
cases. 6 cases you
Six
got, 6
total
cases you have not got.
Yes.
So give that chart and come tomorrow. And just you also verify whether what kind of flight risk you apprehend.
ୟୁଏସଏ ଯାଇଛନ୍ତି ତ ଯାଉନାହାନ୍ତି ତାଙ୍କ ଡକ୍ଟର ପାଖକୁ ଯିବେ then any case he has to with condition.
How many children you have?
I have 1 daughter only.
He one daughter. Then he let him go. Come with the chart, I will allow. Yes.
May I plead your lordship? The petitioner is initially implicated in the case under section 13(2) read with 13(1)(e) of PC Act along with 109 of IPC, your lordship.
Yes.
In the year 2015. Here all the properties were valued, your lordship. And the petitioner having a house, 2-story house, that was valued above the rate, your lordship. That property was constructed by the petitioner in the year 2010, your lordship. But its valuation was taken as per 2015-16, your lordship. For which
Then in the 482 I will value it.
no, your lordship. For which I have filed an representation to the authority, your lordship, to evaluate as per the 2009-10 valuation, your
Where
lordship.
is that representation?
That is annexure 2, page 14, your lordship.
Yes.
And it is still pending, your lordship. I have annexed all the documents that the,
Yes, Mr. Marana,
the,
consider this.
Concerning the accordance with law, your lordship, in dispute.
Learned in the what? Regarding the income of valuation of the building in connection with which building is that?
that is over plot number 3780 by 5894. Your
This is
lordship,
one of the property taken into consideration.
that is page 9, etc. First property.
Item 1 of the immovable property.
Running page 9. Your
Page 9.
The petitioner is facing the trial.
No,
Facing
charge sheet
investigation.
is-
Charge sheet has been filed?
No,
No, your not yet.
Petitioner is facing investigation. And with regard to the vigilance PS case number 63 of 2015 under section so and so in the list of asset insofar as the first asset is concerned, according to the petitioner, the valuation of the first asset in the list of assets
Immovable property.
exorbitant. He is exorbitant.
Under immovable.
Therefore, he has given an representation to the Director General of Police Vigilance for reevaluating the assets. Full stop. His grievance is the said representation is not yet been considered by the concerned authority. Therefore, he seeks indulgence. Mr. Maharana appears for the opposite party states that
The evaluation in the meantime done by the technical team in presence of the
valuation of the property has rightly been done, and insofar as the representation is concerned, the same shall be dealt with in accordance with law. Accordingly, the petition is disposed of with a direction to the opposite party to consider the representation
under Annexure 2.
Under Annexure 2 in accordance with the law.
How do you?
Decide it whether valuation or no valuation. How does it?
I've annexed all the documents, your lordship.
Whatever you impress upon that. I can't evaluate it. If
No.
you have a good case, they themselves will do it.
Obliged.
Non-officially also I was talking with the IO. Sir, se କରିଛନ୍ତି already.
ଏପଟ ସବୁ ଟିକେ ହେଇଥିବ ଦେଖିବ।
ସିଏ କହୁଛନ୍ତି 10 ମସିହାରେ ନବା କଥା 14 10 ରେ ଗୋଟେ କରିଛନ୍ତି ଉପର ଭୋଟଟା 14 ରେ କରିଛନ୍ତି।
That is my grievance, your lordship. That is my grievance.
10 ରେ କମ ଥିବ।
That 10 ରେ we have applied there are 3 connections. ସବୁଗୁଡା 10 ରେ ହେଇଛି। Town planning approval 10 ରେ ହେଇଛି, but they have assessed around 2014.
ତ ଟେକ୍ନିକାଲ ବାଲା ଯାଆନ୍ତି ନା ଗୋଟେ ଟିମ୍ ଯାଏ ସେମାନେ ଦେ ଇଭାଲୁଏଟ୍ ଆଉ
That would be a good defense for you also in the trial.
ନାଇଁ ସେମାନେ କନସିଡର କରିଛନ୍ତି ବୋଲି ମାନେ ଆଇଓ କହୁଥିଲେ ବି ଜଷ୍ଟ
ସେଇଟା ହେଇଗଲା ଆଉ there will be no DA, your lordship.
It will come less than 100.
ନା ତାପରେ ବି ହଉଛି ତାପରେ ବି ହଉଛି
And he will be covered by that notification.
ନାଇଁ ନୋଟିଫିକେସନ ଟା ଟିକେ ବର୍ତ୍ତମାନ ସାର୍କୁଲାର କଥା ସେ କହୁଛନ୍ତି ସାର୍କୁଲାର ଆମର ଡିସନେବଲ କୋର୍ଟ ସୁପ୍ରିମ କୋର୍ଟ ଅଲସୋ ଲର୍ଡସିପ ନୋଜ୍ ଦ ସାର୍କୁଲାର କ୍ୟାନ୍ ନଟ୍ ସୁପରସିଡ୍ ଦ ଷ୍ଟାଚୁଟରୀ ପ୍ରୋଭିଜନ୍ସ
But they will
I have annexed one circular by the government.
that will be your defense. But you can't ask for quashing of that.
No. I'm not praying for that, your lordship.
Anyway, now
Obliged.
Yes.
311 petition was rejected by Honorable Court below on the ground that section 33 section 5 is barred and the victim being a child shall not be called for repeatedly.
Rightly.
My lord, my humble submission, my lord, the day which was the child victim was present
by the accused, my lord, before the learned trial court.
To call
33(5).
My lord,
again, same problem.
no, my lord, in this case, this is different. I have framed the questions, proposed questions, my lord, at page 7.
Cases you want to re-examine?
My lord, the victim, her father and mother, PW 1, 2, and 3. And no, there are number of witnesses.
You say that similarly the vital witness, the informant has been cross-examined by the state council and he left some material points regarding PW 2 and 3. PW 2 and 3.
They are prepared to recall PW 1 to 3.
1 to 3, my lord. My respectful
One is the
submission,
victim.
my lord. She was,
Show me their evidences.
my lord,
Why have you not cross-examined? Let us see.
my lord,
Straight away I will allow your petition.
my lord.
Mother and father,
My
one
lord.
opportunity.
My lord.
Mother and father, let
Yes.
mother. No victim.
Yes.
Okay.
Oh, my lord.
PW 2 and 3.
My lord.
The petitioner is agreed by order dated 23/11/2023, passed by the additional district judge fast track Cuttack in GR case number 91 of 2016, whereby his application under 311 CRPC is rejected. The applicant, being the accused, moved an application seeking recall of three witnesses, namely PW 1, 2, and 3. PW 1 is the victim.
Yes.
Victim, whereas PW 2 and 3 are the mother and father of the victim.
Yes.
Full sir. In the application under 311, he has proposed the questionnaire. Taking into consideration the statutory bar under section 33 clause 5 of POXO Act, I am not.
The part one matter, and again, this is been as per the direction of the
Therefore,
honorable.
I am of the view that the matter should be placed before the honorable to assign the matter to the appropriate bench, the director.
As far as this case,
But is there any noting of the honorable chief justice?
maybe.
My lord, it was referred because it was heard in length by Honorable Justice S.K. Mishra. Now it came to my knowledge that similar petition by co-accused is pending in CRLA. Before Honorable Justice S.K. Sahu by co-accused on the similar point that cooperative
No.
society is not coming under the
No.
OPID Act.
You're most confused.
Petition is with me.
My learned friend is most confused. That is a petition raised. That's a petition is an appeal against the order of the lower court. And this is a petition not against any order.
Okay.
My lord, as far as this case is concerned, the petition, I have filed this petition challenging only a very specific thing. Section 6 of OPID Act is not made out, and it is not applicable as per the provisions of OPID Act. And basing on that,
No, what he has taken.
okay, he has taken, as far as that is concerned, I have, as per the OPID Act.
Alok Das has filed any petition.
No, co-accused, Anshuman Naik. Co-accused.
Okay.
Co-accusing the same FIR.
Maybe, I
Yes.
don't know. I don't know. He has filed
Yes,
for
that's
what?
he says.
Yes, Anshuman Naik and
That they have challenged the order of charge against the order of charge. Charge has been framed, they have challenged on that way. And that's a different issue.
Right,
Framing.
arising out of the same FIR, it should be analogously heard.
As far as that the provisions, something very confusing right here.
No, that's right, on merit,
I'm
I'm
coming.
not on that. On technicality, if the co-accused have approached this court for quashing or for charge, whatever, and you are raising, he might be raising the same point.
Maybe.
Obviously. So it should be heard analogously.
Okay, then those matters may be tied out with this one because it is at the fag end.
I can't bring that matter.
Now the question comes. Now, let me tell you something. Just I will take 1 minute of yours, Lordship. What has happened? The thing is that section 14 says any person, including the competent authority, if agreed by an order of the designated court, may prefer an appeal to the High Court within 30 days from the date of order. All those cases are against this framing of charge. As far as that process is concerned, they cannot go away from that one. We have to charge. But this is a specific, it is a long back, it has been filed, and this is with a very specific prayer that 6 OPID Act is not maintainable here in this case as per the provision of the statute. This is the matter of the case, and certainly that may be a part of that case. But
you are asking passing up
6 OPID Act only.
That read court can do it. When 482, how can?
For 482, it is maintainable in 482.
No, you go to read court. You are challenging the virus of it.
No, I am not challenging the virus of it. I am challenging here.
That's what you say in the prayer.
What I say, when the 6 OPID, this is on only one wording. I would like to.
If you can tell very well that 6 OPID Act is not attracted in this case.
Exactly.
482 is maintainable.
Yeah.
The moment you question the validity of that provision.
I'm nowhere.
What do you say?
No.
Was section 6 of
6 of OPID Act.
From city case.
Exactly.
Okay.
I'm not saying the entire case to be quashed. I'm only that part.
I thought the provision itself.
No. I'm not saying, because basing on only one word, the entire case is based on only one word. That is called control. Okay. In section 2D, OPID.
What are you?
Madam?
You are
The secretary of the society.
I'm the secretary of the society, cooperative society.
Group housing. Cooperative society.
Cooperative, that's a cooperative society.
Group housing society.
No.
Group housing society. No. It's a cooperative society.
Cooperative society. They be moved.
Not there here. You can see it from straight away. At least these acts you should keep. Yes, you please read by that time.
Okay, as far as.
Get it from what is it?
आओ बोही नहीं कहाँ पर अपन बार बोही चीज़ दो ना दी दे दो उठा
Where are the others?
दियन मत दियन बार तो दे
Let the minimum bare should be there. Yes.
Okay, as far as section 2D is concerned,
yes,
that is connected with 2D's financial establishment. Financial establishment means an individual or an association of individuals, a firm or a company registered under the Companies Act 1956.
2D, huh?
2D.
Yes.
Repeat again. Financial establishment means an individual or an association of individuals, a firm or a company registered under the Companies Act 1956, carrying on the business of receiving deposits under any scheme or arrangement or any other manner, but does not include a corporation or a cooperative society owned or controlled by any state government or the central government. This is the crux of the case. And my submission, my lord, is
only exception is if it is controlled by the state.
Yeah, that is my submission, my lord. As for this to suffice my submission, the basic only word is control. To justify myself,
This is whether you are controlled or not.
Exactly.
That's a tribal.
Exactly, that is the only thing. And to be tried. And trial that cannot come out because
there are many factors. It's kind of Article 12 instrumentality.
Exactly.
Is a wider connotation.
My lord.
That has to be seen.
Okay.
Whether, anyway, let us see. How do you say that you are not?
To justify that, now I have filed a lot of Supreme Court decisions on a memo.
Now, on facts, you tell me.
On facts.
Decision will not have help. On facts, whether you are being controlled
facts
by the state
until
or
and
its instrumentality or not.
My lord. No, or coming down to the facts, it is necessary to understand what is control. Control, it is means High Court. So let me start the example from High Court. The lower courts are not maintained by High Court, but they are controlled by High Court.
No, but by illustrative example, you can't. You have to tell me the facts whether
I'm coming.
You are directly controlled or the instrumentality of the state is controlled.
I'm coming. I'm coming. My lord, I am coming down to that.
Yes.
For that, Please bear with me. Just I am giving you some connotations of the word controlled is synonymous with superintendence, management, or authority to direct, restrict, or regulate. Control is exercised by superior authority in exercise of its supervisory power. Again, it has been explained. The word control suggests check, restraint, or influence. Control is intended to regulate and hold check in restraint for action. The concept of control implies that the controlling officer must be in a position to dominate the affairs of its subordinate. It, unless otherwise defined, would be synonymous with superintendence, management, or authority to direct, restrict, or regulate, exercised by a superior authority in exercise of its supervisory power. It may amount to effective control, which may either be de facto or remote. Now coming to this case, as far as this case is concerned, my lord, undisputedly, this Nilachal Multipurpose Cooperative Society Limited is a cooperative society registered under Odisha Cooperative Society Act, wide registered number 204JD48 2010.
Yes.
Yeah, this is undisputedly okay. When the moment it is accepted, a company as a cooperative society is registered, it is governed under the acts and rules of the Cooperative Society Act. It is undisputed. We cannot go beyond that. And that also the opposite party also admits this. If that in this circumstance, what I will say, this is an organization which is a registered organization. Okay, when this the matter stood thus, what happened in the year 2020? In the Register of Cooperatives found the management committee of the NMPCSL, this cooperative society, is in persistent default, negligent in the performance of its duties imposed on it as per Rule 39(1) and 2.
What are the allegations against you?
The allegation is, as far as they say, coming down to the FIR.
Today they only will say.
Collected money from the members with a promise to pay high returns. Collected from members about 5 crores and misappropriated the same, and money has been transferred to their own account.
This is the allegation, right? Now comes again. I will come to the.
We are in the realm of allegation only.
Exactly, we are at the helm of allegation only. Now I am not bothered. I am not approaching your lordship, this honorable court, to say that the case should be quashed. I don't disagree with that.
Has to be quashed.
But only Section 6. Section 6 is absolutely meant for a financial establishment.
What are the other associated offences?
420, 461, 468, 471, 120B IPC. Okay. My submission is, it is only connected with Section 6 of the OPID Act. This is because this is not maintainable. It is because my organization, this organization is controlled by the government. And to establish that, they have themselves have established in the year 2020, the state government has superseded this society and taken over the management itself. That is annexure 2020.
That was challenged in Supreme Court and all.
Which one?
This notification was challenged out.
No. Yara challenge. Yara
they abolished all the management
exactly.
And they have taken over.
They have taken over. That was a challenge before the Supreme Court.
Right.
My lord, I do understand.
I was the counsel there, therefore
I know that. So this is since 2020, it is under the direct control of the government. Direct control. Now question comes, under which authority you have taken this? It is because you have the power to control at any moment. And in their counter, they have also mentioned in the
so
what they have
you are
said.
relying upon 19. Page 19.
Pardon?
Page 19 you are relying upon.
Page 19.
Consideration of the proposal of ARCS, Jaipur Circle. And
Aigya. 19 tapore pore achi.
The appointment of administrator.
22 re semane
Modified. The administrator do hereby appointed it with respect to cooperative society to manage the affairs of the concerned society.
Aigya. Moda. Tapore dekhontu page 22 re.
Yes.
On page 22.
20.
In pursuance to order number the I Sri Sarat Chandra Malik, SRC, Jajpur Circle, charge of administrator of NMPCSS.
Yes.
Now as far as
Taken over the
taken over.
Yes.
Now the question comes: if they don't have the control, how could they taken over? How could they taken over this one?
When the alleged offense?
Pardon?
Alleged offense?
It's a continuous offense. It's a continuous offense. This is an economic offense, they say. And second part, this was first part. In my written argument, I have detailed because it was at the fag end. And as far as this part is, second part is concerned, they say deposit and depositors. They use the word deposit and depositors. Now a very weak question arises. They in their counter say, you cannot deposit a single pie if you are not a member of the cooperative society. And once whatever amount you deposit, that is the share of yours in that cooperative society. And most importantly, all those members, who is the most powerful person? One thing that is very clear is the most powerful body of a cooperative society is general body. General body. And general body consists of all the members only.
General body is supreme.
Supreme. And the entire system, general body consists of only members. You are members. You on your FI, you have said we constituted a cooperative society. You have deposited, and there it has been written why they couldn't pay it. It is because the loanee have disbursed a lot of amount on the loan, and as they fail to disburse the loan amount, collect the loan amount, this becomes sick. And in this here also. What they have
In nutshell, what you are trying to say is it is a completely a case of mismanagement on the part of the management will not bring mens rea for the purpose of 6. That's what you mean to say.
And 6 OPID is strictly prohibited as per the OPID Act. It's strictly prohibited. 6 OPID is not maintainable in this case. Rest part I am not connected. Yankar jo counter dechandi. Counter ati last page go.
Counter.
Government counter.
Yes. Affidavit of opposite party. Yes. Which paragraph?
I am reading that one. Second meeting of management NMPCL was held under presidency of administrator NMPCL.
Where are you reading? Which paragraph?
The first one, this one, first to Arambha Guruji. Last page.
The resolution.
Resolution, last page.
No, in the counter.
Counter
Counter starts at page.
Paging
Affidavit by opposite party number 2.
Again?
Affidavit by opposite party number 2.
Milord, I am for the information.
Opposite party number. Affidavit filed by opposite party number 2.
Yes.
Again.
Page 6.
Page 6 or 7. 6 is meeting of committee that starts.
Yes.
The next page, Melo.
Page, okay.
Next page.
Second
meeting of management NMPCL was held under presidency of administrator NMPCS on 16/7/2020 at Jajpur Road. Current crisis of NMPCS due to non-payment of salary at an NINL since February 2020 was discussed. Payment of maturity amount of members deposit is pending due to non-recovery of loan principal. Administrator NMPCSL advised Secretary NMPCSL to make discussion with members with pending loan and to collect the same in installments and pay out maturity amount in installments. Administrator NMPCL received previous loan recovery and maturity payment. And it was concluded that present crisis is due to long-term non-payment of salary at NF. So this is the circumstance. All those members, those who have formed this company, they come to this court and say, give us our money. And that's the come. Now I am not connected with that. I am not going to that phase. Let the case continue. Only my submission, only my point is this wrong implementation
You
of
are
6
appealing-
OPID Act.
My lord, I am for the informant.
Informant. What do you say?
My lord,
You are one of the members.
Yeah.
Yes, my lord, I am the informant. I am one of the member. My humble submission before this, before your lordship is that kindly peruse a few points from the petition itself, my lord, where they admittedly say that since from the beginning of the society, 4/8/2010, they are in the administrative control of this present petitioner and other accused persons. Thereafter, till 13/7/2020.
Now you simply say whether this society government controls
No, my
society.
lord. That is what the crux, because my learned senior wants to take that part from the specialized of Act 2 to general Act. But it is applicable, my lord, in view of that, the offense that had taken place, that is quite before when the government took over. Even the government took over as per annexure.
How can the government take over if they don't have the authority to take over?
My lord, as the Society Act says, they taken over because of many faulty action of the present management.
So then supervisory capacity is there.
No, my lord.
Government.
I am reading.
Therefore, the government saw that these people, they are not able to manage, so they have taken over.
No, my lord. Please kindly peruse the annexure 4 filed by by the petitioner itself.
Yes.
My lord, annexure 4 says to after taking over, to manage day-to-day affairs of the NMPCL till information of the board of formation of the board of directors, following till a team will work under the guidance of the administrator NMPCL. Alok Kumar Das, again the secretary of NMPCL, Manoj Bal, Vikas Kumar Khillar and Anshuman Naik. They again given the charge. So it is not like that charges has been taken, power has been taken away from the present petitioner or the other co-accused person. Now, so far as control is concerned, my lord, kindly peruse the same provision of the Act. My learned here is saying that it is owned or controlled. My lord, neither this is owned by the government, nor as per this resolution is controlled by the government. The government is just an administrator. As per law, administrator is there. But these people are directly under the controlling the affairs of the society. An important thing, so far as his submission is that the petitioner submissions that the loan amount is quite low as compared to the total deposit. Deposit is more than 5 crore rupees. Loan is only around 1 crore or something.
Where is that?
My lord, I am presenting.
You are on bail.
My lord, I am
bail.
Pardon?
You are on bail. Yes.
About 600 that during investigation there are about 600 members of the society. My lord, I am reading page 2 of the counter affidavit filed by the OP number 2.
1 minute.
That
1 minute.
para 5
1
under
minute.
page 2.
1 minute. Page 2, huh?
My
Yes.
lord.
Yes, para 5. Reading.
Lord, that during so far investigation, there is about 600 members of the society at the end of year 2021. On the basis of the document produced by the secretary of the society, out of 600 members, about 300 members deposited their invested money in the society in different schemes of the society, which amounts to about 5 crore. And the loan to be recovered from the loanee amount 1 crore 60 lakhs. And it is a record on the material on record that amount has been transferred from the society fund to the individual funds of this office bearer of this company, including this petition.
Individual account.
Yes.
Charge sheet also mentioned.
So under what capacity and what power you are misappropriating the fund? Finally, my lord, under para 7, it is clearly stated that Sri Alok Kumar Das is the
Then if it was under the control of the government, how have we withdrawn the money and
I am coming
put
to
it
that.
in your...
My lord, I am coming to that. As far as this submission is concerned, for the timing.
Say, your case is because of the pressure on the recovery, non-recovery. The payment could not be made.
The administrator's fees.
But the para 5 says that the recovery is 1 crore and deposit is 5 crore.
Okay, if that is the circumstance,
That is again a tribal issue.
then I am coming to that. No, not disagreeing with that or agreeing with that. Whatever they say, it is let it be there. Now my question comes: if that is so, I don't say the case to be quashed. Only I say let the case come, let the case be tried. If they have done something, they have to be punished. I don't say this. What I say again on that point, I suppose for the time being, let's not accept that is true. And when the registrar of cooperative society came to know that these things has happened, they have taken over.
Anyway, let us see the what you call the allegation against.
Pardon?
Allegation against. Let us
Allegation.
come to the allegation.
14 to 17.
Let him. He will point out. Show me the allegation. Allegation against. You are Alok Kumar Das, huh?
My lord.
I place the charge sheet.
Yes, page 16. Come to 16.
Charge sheet they have not filed.
Charge sheet is not there.
They have not filed charge sheet. They have filed a supplementary preliminary charge sheet.
What
Again, that is under challenge.
Yes. Charge sheet, where is that charge sheet? Read out from charge sheet.
Let us record it. On the written report of complaint, Bonita Mahapatra, so and other several report case has been registered and investigated into. During investigation, the complainant and other depositor have been examined deposit receipt, bonds, share certificate relating to deposit of money in society have been seized from depositor and left in GMAT. The seized deposit receipt share certificate contain the signature of President, Secretary, Joint Secretary, Treasurer, and other office bearer of society. Also seized 2 loan register, attendance register of staff, Sri Mandir, maturity bond, 98 blank check, other documents from accused Anshuman Naik and accused Alok Kumar Das. Only 2 minutes register Sabhabai of society were seized. The depositors had deposited their money in society with false assurance of high rate of interest of 18%. Since the inception of society, there is no document. The register maintained in the cooperative society related to income expenditure of society as per bylaw. No auditor report has available neither from the office of society nor from the office of ARCS. Sri Mandir shopping mall was opened managed by society in the year 2013 with an initial investment of 12 lakhs. The document regarding income expenditure were not found neither from the office of Sri Mandir nor from any office bearer of society. Staff of Sri Mandir, whereas the investment in Sri Mandir has increased by day as per resolution 15 and 19 dated so and so. Funds of society were directly transferred to the account of Joint Secretary Sumant Maharana and to the account of Secretary Alok Kumar Das and Treasurer
Personal account.
Yes. And Manoj Kumar Bala for management Sri Mandir as per resolution so and so. Vikas Kilar was appointed as CEO of Sri Mandir.
That resolution is general body resolution or executive body resolution? By which the money was transferred?
Not mentioned.
Verify and tell me. If it is general body, then he is out. If it is executive body, then he is in.
Although the management has stated that audit are done by private agency, but audit report has not been produced by the management. All the management.
Okay, I understood it. You just tell me whether it is general body or not. But all these things appears that they were doing all kind of mischiefs and all.
But so far as the manage and control is concerned, Miller, the state has to act as per the Society Act. If this proposition will be accepted, then every company will be a state because he has to register and the liquidator is there. The control and management is not under
just verify and tell me.
Miller, that two resolution.
May I, Miller?
Yes.
This is a resolution of governing body, not general body. Basing on that.
That's the problem.
That's all.
5 of you sit and pass a resolution,
Exactly.
not ratified from the general body, and transfer the money to your own account.
Exactly.
Then it is done.
Done. That is why, my lord.
That indicates that the government has no control.
No, I am coming to that. No, this is not the point.
Reading one line.
No, my lord. No. No, my lord. I am not coming to that.
That would be a.
I am coming to. I am coming to what? I am coming to what? Once
If the governing body resolution by which the money is transferred from the society account to your account, have you ratified it in the
now
general body?
question comes, now he has written this charge sheet is a preliminary charge sheet, not a charge sheet. Subsequently, they say this Ansuman Naik, the money has been transferred to Ansuman Naik and this towards their loan amount, towards their investment. They have taken it away. Whatever it is, I'm not on that. My only submission is, I don't say they are I don't say anything. I say they have done it. Let us for the timing accept they have done it. More only submission. I say section 6 is not made out.
Section 6, I'll tell you, section 6 may not help you because these kind of societies are directly controlled by the general body.
Exactly. That is my submission.
General body, not by the...
Not by anything. Once if it is controlled by general body, then what made this informants?
Every action behind the back
Exactly.
of general body
is illegal.
Ratified by the by you in the general body.
Exactly.
If you have not ratified, you can...
Exactly. What has happened here in the instant case? When all these illegalities took place, from the beginning I am saying, I am not supporting whatever. My submission is, when government came to know that all sorts of illegalities are taking place, they superseded. Under which provision? Section 39(1). And what section 39(1) says? Clearly, 39(1) says, subject to the control and direction of the state.
Society Act.
Society Act. Rule 39(1). Devi.
Have you reproduced that in written submission?
My lord, I have given it.
Where is that?
Written, they don't know. Page 5, written submission. Page 5.
5, huh?
Okay.
Yes.
Page 5.
32(1).
39(1). 39(1).
Society shall submit such report, statement and return to the registrar of the cooperative society year and for such period in the forms specified by him, and shall prepare here with him. Yes,
39(1). 39(1), subject to the control and direction of the state government. Every society. Clearly it says it is controlled. Once a society is registered under Cooperative Societies Act, it is directly under the control of Register of Societies. That is only my submission.
All the societies are out then.
Yeah, exactly.
And what was the necessity for section 6?
Pardon?
What was the necessity?
Section 7. That is my point. Now,
two kind of society.
My lord.
Society is controlled by the government.
Yeah.
Another society is not controlled by the government.
Not controlled by the government. Once
so therefore, section 6 has come in.
No, section 6. Once a registered company that is covered under section, that is not covered under section 6. Obviously, my lord. My lord, we have to stick to the law. What I say, once it is registered and you are inspection regularly DR AR inspection you are doing everything. Misappropriation that everybody, all of us know what is happening in all cooperative societies. Nobody, it's not a hidden one. I mean, they are being managed. You cannot go away from that. And as far as these members are concerned, depositor. Now question comes, depositor. Are they depositors here? They are the members of the society. They are responsible for that.
How many times this from 2010 to 2020? How many times election has happened and who are the office bearers repeatedly?
I think 1 or 2. First time they are, second time they
same people.
Same people.
Secretary sometimes.
And same thing.
If 5 people might be doing it.
And second thing, one submission. Wait. Just let me complete. One submission, very interesting part.
Within 2010 to 2020, this accused person, particularly this gentleman, Das, how many times he was holding office? And
since the beginning. Since the beginning, he is holding the office. Since the beginning, he is holding. I am not on that point, my lord. I am not on that. That is the reason why I say, let the case continue.
I understand.
Offenses of
File
IPC.
your
How can you do this in section 6? And what he said, a very interesting part he has told, what I had forgotten. ସେ କହିଲେ ସେ ଯୋଉ ଦେଖେଇଲେ ଇଏଟା ଦେଖେଇକି annexure ସେ କହିଲେ ଯେ ସେମାନଙ୍କୁ ସେମ୍ ଲୋକଙ୍କୁ ରେସ୍ପନ୍ସିବିଲିଟି ଦିଆହେଲା who gave me gave your administrator the administrator government has he has given
everything is
managed. It's an open secret. We know everyone what is cooperative society. We cannot go away from that.
Milord, my anxiety is that similar issue. The discharge petition was challenged in the CRLA.
When that matter is listed?
On 26th it is posted, and discharge petition was filed before the lower court. They on the same issue that is not coming under the OPID Act. And the amendments also made in the CRL petition, that is the same issue, that it is not covered under.
So I'm keeping it again on 29.
Lordship may tag that, call for that.
No, I will not tag it 29 because that is a revision, maybe revision.
That is an appeal. That is a statutory provision.
I can't.
That can never be tied up with this one.
Lordship may say.
I am keeping it on 29th. You file a written submission.
Exactly.
I understood it now. I will dispose it up. 29.
Milord.
Obliged.
Yes. 26th, what is happening? Just see. And prepare that
resolution. Yes.
Yeah. Okay. Next.
Lordship, on behalf of SP Das, kindly be taken after 1 week.
Urgent.
God bless.
Lordship. I'm VC from Rautla.
May please, Your Lordship. Item number 39, my lord. Here, Your Lordship, the petitioner number 1 is the ex-MLA of Fulwani, Your Lordship. Your Lordship may kindly turn to page number 11, the FIR, my lord. The prayer of the present petition is that, my lord, quashing of criminal proceeding, because, my lord, initially, a FIR registered under 170, 417, 419, 384, 395 of IPC against unknown person, Your Lordship. Thereafter, my lord,
what is the charge sheet? What charge sheet says? You tell me.
Charge sheet is at page number, Your Lordship, may kindly show you. 16. Page number 16, the only offense is 395 against the present petitioner's man.
Yes, then why should the proceeding will be quashed? Because you are XML.
Lordship may kindly turn to the page number 51, Your Lordship.
51.
Page number 51, my lord. The complainant himself filed this affidavit before the learned court below, Your Lordship, where he mentioned from the electronic and press media, it came to my knowledge that one ex-MLA of Fulwani constituency, Devendra Kohara, and Srinivas Kohara, the present petitioner number 2, were arrested in my case number this. My FIR is unknown, so also my statement recorded on the CRPC also not disclose the name of any assailant. Moreover, it is clearly mentioned that soon after arrival of the police, the assailant were fled away from the spot. So question of identification of the assailant at the scene of occurrence does not arise at all. These accused petitioners were not present at the time of occurrence. These accused petitioners are innocent and falsely implicated in this case, Your Lordship. It is the affidavit filed by the complainant before the learned court.
This affidavit, what was the occasion for him to file this affidavit?
Because, my lord, the complainant came to know from the electronic media that one ex-MLA is arrested in this matter. Having a reputation, he arrested in this matter in a false case by the police officials. For that reason, he filed this affidavit before the learned court.
Bail, on the basis of this, bail is granted.
Yes, Your Lordship.
He was put to TI parade?
No, my lord. Police conducted the investigation without having any TI parade. Also, the petitioner also, the complainant also working at New Delhi at Rashtrapati Bhavan. He is Raj Sahi of that Rashtrapati Bhavan.
Yes, but in this case, my lord, what happened during course of investigation, the petitioner was arrested and 30,000 rupees, my lord, recovered from his possession. And that has been seized, my lord. That happened, my lord, one of the co-accused, my lord, filed CRMC number 655723, my lord. That is also pending, my lord. And all the case diary available with that record, my lord, can.
But which
CRLMC 16572023. My friend also filed that case, my lord.
17?
1657-2023.
Listed today.
No, my lord. Both the cases will taken to court. And case diary, my lord, major part of the case diary.
Tag this matter with the
1657-2023.
1657-2023 and list the same on 6.
Yes.
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 Because case diary is there in that file.
That file.
He can't assist.
And carbon copy here, my lord, that has not been visible.
So therefore, unless the case diary, because the last order says that last order says that bring the case diary and assist the court. Up to date case diary to be obtained.
59 of 2023, my lord. The last order is up to date case diary may be obtained.
That's right.
That is available, my lord.
That is available, but this is available in the connected matter.
Connected matter. This
so
case,
therefore, I am calling that connected matter
my lord.
Along with this, and we'll hear.
But here the carbon copy sent by the IO, my lord, that is not visible.
Let that file come. We'll see. Okay. Fix it.
For the proceeding, if possible, your lordship may kindly correct.
No, we will come. You move application, seek adjournment. Yes.
Your Lordship, on behalf of S. Matthews, the item may be adjourned. Lordship, the item may be adjourned for next day.
Speak little louder.
Lordship, the item may be adjourned. He is unwell.
40 adjourned.
That is one of the opposite Republic of India. Mr. Naik is appearing.
Mr. Naik.
Yes,
in
sir.
item 40, he is seeking adjournment.
Lordship, I give a longer date, possible as last
He
date
is
also.
asking adjournment, you are asking for a longer date. Let him ask whatever you want to ask.
Or kebesin.
Any date.
First, the last week of March. Full. First week of April. First week of April.
Obliged.
Leave a date. First week of April. Yes.
May it please, Your Lordship. 41, Your Lordship, directed for the personal attendance
Yes.
of both the parties that are present before this honorable court today. And I'm filing the joint affidavit in CRLMC number 4220 of 2023, along with the Wakalatnama for the informant.
What is this matter? 263 of 23.
This is the restoration application that the informant in my case had filed because the CRLMC that they had filed for quashing got dismissed for
There is a
non-prosecution.
case and a counter case, my lord.
There was a case and counter case.
Counter case, that has
Your Lordship directed.
my
Now
lord.
they have settled this.
My lord.
What is the offenses?
The offences was, my lord, 354,
Okay.
448, 294, 323,
And
506.
what is the cross FIR?
The cross FIR was almost the same except for 354. They were the tenant and owner of the house. And there
You
was,
are the owner.
I am the tenant.
I'm the owner. I'm the owner.
You
Your
were there, you are not leaving the house. He
We-
came and attacked.
There was a dispute with respect to parking of bike.
Now you settle.
Yes, my lord.
Vacated the house.
I vacated the house.
No, my lord, that
Your Lordship.
what happened, my lord, in the around the CRLMA 263-2023, my lord. That is their case, my lord. So far the counter case is concerned, my lord, that case has disposed of due to non-appearance, my lord. For that, for restoration, they have filed CRLMA.
My lord.
Let it go to the my lord, the
Your Lordship directed the matter to be listed along with.
Restaurant classic.
my lord.
Lordship, for CRLMC
My lord,
499, I'm also
restaurant,
filing.
my lord, it is the year of 2022. That's good for another place. Not assigning to register. That's the problem.
My lord, we have been filing memo. It is not being listed. Your Lordship directed it to be piled up together.
I will quash this FIR.
My lord.
And you show that in that court and get it quashed. What to do?
Well, it will be difficult on our part
No,
to get it
that's right,
listed.
but I don't have the assignment. I can't entertain.
My lord, CRLMA go to the my lord, the assignment
CRLMA.
bench.
So that
And there the court will restore one that.
which court dismissed?
My lord,
My lord,
the Honorable Chief Justice
Chief
Court
Justice, then,
back then.
Justice Dr. Murad.
The division bench as it used
But
to
it
be.
go to the CRLMA bench. And CRLMA, my lord, the court is competent to restore the.
You do one thing.
My lord.
You file a fresh petition. See, let her file a fresh petition.
It will better.
And it will be listed here. Come on, 23rd.
Then my lord has to.
So that technicality is taken.
They have to withdraw the CRLM. They are incompetent.
Withdraw whatever you do, but you file a fresh one so that that matter,
Both the cases.
as per assignment, it will come here. I'll pass both. The
My
things. Otherwise, half-heartedly you have to do it. No?
My lord. My lord.
That's the best way.
Yes, my lord.
File it a small 2-page petition and release it.
Yes, my lord.
Okay, Friday.
My lord, your lordship fixing it to 20.
This for 23rd.
23rd.
23rd. Grateful.
23rd. You come to
Grateful.
today itself.
Grateful.
Get it numbered and it will be.
Well, I'll file a memo for mentioning.
You mention it once you file, you mention it. I'll get it listed on site.
Grateful.
Okay.
Grateful.
So that this technicality will not come in here.
Yes, my lord.
And that insofar as that MA is concerned, to withdraw it.
My lord.
Okay.
42. May it please, Your Lordship. Item number 42, my lord. Here, Your Lordship, the petitioner filed the 482 application for default bail, my lord, in absence of C report. Here, my lord, the impugn order clearly says that the petitioner applied for 167.
How many, Mr. Sahu, how many matters you have filed? Similar matters, huh? Every third matter you are appealing and getting an adjournment. Yes. What happened in this matter?
Here, Your Lordship, the present petitioner filed 167 subsection
Again, 167.2. Where is your application? You are on bail? No, you are not on bail.
Bail. It is for default bail. The 482 application.
You are on regular bail. You can. Mr. Maharaj. See, insofar as 167.2, in the absence of
chemical examination report, yes.
That matter is pending.
Yes.
So, what are the general order passed by it?
Two different orders have been passed by this honorable court.
Yes.
One is my lord.
Mr. Ponda had been arguing that matter.
That is item 19. It has been passed over. After lunch, milords, I have got.
What is an assessment?
Appointed. Can it come next week?
I believe you are arguing this matter somewhere else.
Which one?
The same issue.
No,
you are not arguing.
No, other.
What I pray is let that on item 19 be taken up next week any day. And I think meanwhile, Your Lordship may ask the court below to send the order sheet by electronic.
19. I'll take it up immediately after I'll send your junior. I'll do it.
I'll send.
No problem. You need not wait. I'll do that. So what are the orders generally passed? This kind of matters.
I'll show, Lord.
Yes.
I am having all the orders.
We will adopt one of them.
Yes.
And dispose it up.
Yes.
Why to keep pending? Show me. I believe you relegate it to the trial court to decide the bail application and to considering these points.
Yes.
One of these.
One order. Perhaps my senior has given this order, given reference. You'll also may kindly see the relevant portions. Okay. Set up
Which judgment they have case law. Citation. Article not having.
I've highlighted the portion that is the important.
Yes, it is actually granting bail. If it is there,
yes,
it will be taken. If it's not there, there is
yes.
No, it is
There is. That can the cognizance be set?
No, your matter will be taken up. 19. I am not passing you.
Similar order. Similar thing. Similar.
Anyway, he will argue next week.
Yes, Lord.
But insofar as this matter is concerned, Mr. Sahu, the coordinate bench has passed in 2-3 matters, saying that if you have to move an application for regular bail in the court below, if the chemical report is there, it will be taken into consideration. If it is not there, you will be released on bail.
You will be released.
Ahmad Khan or what, my lord? Ahmad Khan and Muhammad Khan. The matter, the London State Council referring to Ahmad Khan judgment, you would say?
Yes, yes.
Yes.
My lord, in that matter, your lordship, in that matter, the Punjab Haryana judgment not considered and Muhammad Arbaz orders are not considered, my lord. That is my submission.
No, what is your case? In your case, whether the chemical and examination report is already placed on record?
Yes, your lordship. But after 180 days, they place the chemical examination report, your lordship.
Then it has to be heard. Mr. Panda, Mr. Devasis Panda
Yes,
is
sir.
also arguing the same matter as item 19. He seeks an adjournment for next week or so. Then I will hear your matter along with his matter.
Right.
Along with 19, whenever you are giving the date for 19, you give the date.
And the angle my friend has, the angle my friend is going, for that also I am having this decision.
Oh, will.
Yes.
I am not also advocate law.
Okay.
No, let's.
I am also prepared, sir.
Yes.
19. Monday, is it possible? Monday.
ଯୋଉଦିନ ସାର୍ଙ୍କର ଯୋଉଦିନ ଫ୍ରି ଦେବେ
Tuesday, Wednesday, ଯେବେ possible ହବ ଦେଖି ଯୋଉଦିନ ହିୟରିଂ ହେଇପାରିବ
ସେଦିନ ରଖିଲେ ଭଲ
ଡେଟ୍ ଦେଇକି ହେଇପାରିବ ନା କଣ ପାଇଁ
ଲାଭ କିଛି ନାହିଁ
ଯୋଉଦିନ ହେଇପାରିବ ଦେଖି ଦେଇ
ଆପଣ ଦେଖନ୍ତୁ ରଖିକି ରଖନ୍ତୁ ଦେଖନ୍ତୁ
40 ଆଉ 19 ଦୁଇଟା ଦେଇଦେବି
27 ରେ ରହିଥିଲା ବହୁତ ଗୁଡ଼ା ମ୍ୟାଟର ଅଛି 27 ମୁଁ ଦେଖିଛି ଆପଣ ଟିକେ ଦେଖିକି ରଖନ୍ତୁ
ଦେଖିକି ଦେଇଦେବେ ସେ ଭିତରେ
ଦେଖିକି ଦେଇଦେବେ
ଯୋଉଦିନ ହିୟରିଂ ହେଇପାରିବ
ପାଞ୍ଚ ରଖିଦିଅନ୍ତୁ ତାପରେ
ଯାହା ବି ହେଇପାରିବ
ସେଟା ରଖିବେ.
There are many matters. Once you assist, then we can take care of many matters. That is the idea. Mr. Saul, it will be heard, and you got a free of cost senior.
Yes.
To assist the court. Okay. Yes.
But you really consider the original order.
Order is challenged in that matter also, in this matter.
Oh, that is my application. After rejection of 205 application, I approach this honorable fast. Subsequent during pendence of my application,
that was moved. That matter came a little early.
Yes, my lord has rightly imposed cost, but in my case, my lord has imposed cost.
Yes, obviously.
Because my application is
you can't file 5 cases and don't disclose the same one. That's what that is. Anshuman Samantrai.
Yes. One revision application.
No, apart from revision.
Yes.
For the same relief, 2 petitions were filed.
2 petitions.
One petition relief was granted, and the second petition is listed in this court. And in that petition, neither in that petition nor in this.
My lord is absolutely correct. There is no suppression on my PIR. This is the entire individual. Because I filed an application first.
Prior to the application which was disposed of.
Yes. Where is the suppression on my part?
Unfortunately, your matter came subsequently, but the fact remains that in either of this case, you have not disclosed that you have already approached this.
No, more scope nahi na, more scope ko touch mujhe mane certificate da pe. Mu scope joda thile
not the responsibility of your client to tell you that I have already got the relief in another matter, I don't praise it.
Exactly.
And you coming and arguing on the scope of 30205?
Yes. Because my lord knows, a lawyer's engaged brief.
And this is not imposed.
My lord is surprised. My lord's experience is concerned if a junior counsel engaged.
Your client should be facing this consequence because not instructing you the fact that he has approached the court repeatedly without disclosing.
But that's right, but there is no suppression my part. My lord has the para 4 my lord has indicated, that's why that is the difficulty is there.
I'm not indicating the counsel. Where is that? Para 4. Let us see.
Para 4 and
That I have said that in the present petition, for self-same relief, the petitioner has repeated another petition without disclosing, he has already approached this court.
Yes.
Making the same prayer by filing so and so, so and so.
Yes, there is no scope on my part.
Disclosing means it's not necessary that the petition. At least when the matter was taken up, your client had responsibility to tell you that I have already filed and got a relief. So he has not intimated. And you are arguing the entire matter.
Yes, but soon after getting the information that it was happened, so immediately I brought your notice. I supplied the copy of the court.
I think this 5,000 rupees is to pay to the lawyers.
No, I am not worried about money. I am worried about my integrity.
No, I will make it clear that I have no indication about you at all.
Because within 34 years practice, I have never done this.
Yes, of course. I am not blaming you. I am blaming the client. He is not intimated you. And the earlier lawyer also he was surprised when Mr. Maharaj
Earlier suppressed my
and he was losing temper. I said that they are
earlier suppression my lord has rightly imposed cost. I am not in that. Since my application is the first application.
Anything is said against the lawyer. I am saying petitioner.
Seriously, because I took the responsibility of my client.
The client
I have taken my responsibility of my client.
Move application, you will see. You move application that I'll take it on record. That's better.
It is better.
You want to clarify better?
Yes, better.
You simply say in that application that on my part it was not disclosed.
Exactly.
But unfortunately, my matter came up subsequently.
Yes.
That matter it should have been.
That's why it brought to your lordship's notice.
You move that application so that it will come on record.
Yes.
I'll record that.
Obviously, because it has been uploaded.
I'll maintain that 5,000, but I'll record.
No, not my lord. I am not worried about money. I am least concerned about imposition.
That's fine. You should move application, get the record correctly.
Correct.
Tomorrow nobody should raise a finger on you. That's the idea. Move an application. No. And move an application and mention it tomorrow. I'll take it up day after. The application. The application which he moves, take it up day after. I'll clarify that. Okay.
Item 15 now. In compromise,
50. Yes, come on. Yes. What is this offense?
Offense is 420.
420. Okay. Who is you are appearing?
No. I don't pay passover.
Just I'll finish. The parties have
I am for the person only.
Okay. Who is for opposite party?
Yes.
You have implemented opposite party.
Yes.
I mean, implementing.
Opposite party number 1.
Yes. Yes.
Within pendency or parties have entered into compromise.
Yes. What the problem? One difficulty is there. You'll also may kindly turn to page 23.
23. Okay.
I'm reading, Millard. For contra, Millard, second para. Learned additional
23.
Yes, Millard. 23. 23, Millard. Order dated 10/1/2024. 10/1. That's you got?
Per contra,
Right. Vehemently objected the same and stated that the petition of compounding offences at this stage is not maintainable due to the embargo under section 320 subsection 7 of CRPC. He further submitted that the accused in this case was already convicted by this court in GR case number. My lord, that is important. This accused has already been convicted on the same ground in another GR case. So that is why the learned court below not entertained the application of section 320. My lord, let's see what it is. So this is the only difficulties, because he is not the first offender. He has already been convicted. Not that the proceeding is pending. He has already been convicted on another case on the same offences. So that is why this application is rejected. Then
What are the allegations?
420. In that place 420. This present case is also 420.
In respect of other person.
No, where is joint affidavit? No? Joint.
সেটা দেখছে মেনশন করছেন তো দেখুন আর কিছু নেই
But it's all right, but what to do if the complainant himself comes?
No, the rest of your lordship's consideration. Just my duty is to bring this fact to your lordship's knowledge.
Putting him to trial will
Yes,
lead
lordship,
nowhere.
lordship. Because this is the
Was it 420?
yes, yes.
Right. Right. In the instance of opposite party number 2, the FIR number so came to be registered against the petitioners. What is the allegation? Let us see the allegation.
Allegation may not the petitioner took 60,000 from the complainant.
Right. The petitioner took the allegation in the FIR and the DASI are that
the accused persons have taken 60,000 from the complainant in order to provide job in the railway. And subsequently, he has failed to do so for these cases.
How many cases are registered against you?
2 cases. One completed in the meantime, this case is concerned with that matter.
You, it's not that you have involved in many cases.
No, 2 cases.
2 cases. It is alleged against the petitioner that he has taken money from the opposite party opposite party number 1 with a promise to arrange a job for him in the railway. However, he didn't do any favor to the opposite party. Therefore, the opposite party number 1 had registered the FIR. Money you have returned. Then the complainant has started now collecting people for you.
Accused
where is he? What is his complainant case?
Complainant
Ratikant Mahapathi.
This I filed मतलब भीना वाला.
Where is who is Ratikant? ଆପଣ ସେଟଲ କରିଦେଲେ ଆପଣଙ୍କୁ ପଇସା ମିଳିଗଲା କେତେ ମିଳିଲା ରେଷ୍ଟ मतलब କେତେ ଆଗରୁ 30,000 ମିଳି ଯାଇଥିଲା ମିଳିଗଲା କିଛି ପ୍ରୋବ୍ଲେମ ନାହିଁ ଆଉ ये जो ଅଛନ୍ତି ଆପଣ ବାସୁଦେବ ବେହେରା କିଏ ଆଉ ये ପ୍ରମିଳା ବେହେରା ତାଙ୍କ ୱାଇଫ ଓକେ ଏ ବାସୁଦେବ ବେହେରା ଆଉ କେତେ ଗାଁର ଆଉ କେତେ ଲୋକଠୁ ପଇସା ନେଇଛନ୍ତି ଆପଣ କହିବା ଦରକାର ମୁଁ ତାଙ୍କୁ ପଚାରୁଛି ହଁ ଜଣେ ଦେଇଥିଲେ ନା 2 ଜଣ ଦେଇଥିଲେ ପ୍ରୋବ୍ଲେମ ଜଣେ 2 ଜଣ କହିଲେ କେତେ କେସ୍ ହେଇଛି ବାସୁଦେବ ନାରେ ମୁଁ ଆପଣଙ୍କୁ ପଚାରୁନି ଆପଣ ଜାଣିଛନ୍ତି କେତେଟା କେସ୍ ଫାଇଲ ହେଇଛି ତାଙ୍କ କେସରେ 2 ଜଣ ଆଉ ସେଇ ଯୋଉ କେସ୍ ଯୋଉଟାରେ ସଜା ହେଲା ତାରେ କଣ ହେଲା ଜେଲ ଯାଇଥିଲ ଜେଲ ଗଲ ନା ପଇସା ଦେଇକି ବାହାରିଲ ତମେ ତମେ ଚିଟିଂ କରି ଲୋକଠୁ ପଇସା ନେବ ଓକିଲ ଛାପ କରିଦେଲେ I'll quash it, but I'll impose heavy cost on him. I'll have it. He is into all kind of mistake. He has to pay cost. He started blaming the lawyer also. Tomorrow he'll start blaming the judge also, and collecting money from everybody in the village, promising them to arrange jobs. Right. FIR. The petitioner number one and opposite party number one are present in the court. They are represented by their respective counsel and they are being fighting. They file the other copies and all. The parties have filed a joint affidavit. Dated 20th February 2024. Inter alia stating that on the intervention of the village gentries and well-wishers, they have settled their dispute. Therefore, the opposite party number one doesn't want to proceed with the case further against the petitioners. Mr. Maharaja, appearing for the state, submits that the application moved by the petitioner before the court below under section 320
of CRPC
was turned down by the court. Turned down by the court on the ground that the petitioner was involved. GR case number 1753 of he has been convicted by the court below. Therefore, for the trial court rejected the application. Mr. Maharaja, having said that, states that since the parties have now settled the dispute and filed the joint affidavit, this court may give indulgence to the petitioner, subject to imposing heavy cost on the petition. Next, taking into consideration the aforementioned facts, and submission at the bar. And how much cost you will pay? Two of you are there. 5,000 till next date available.
NBW may have stayed, my lord. I have filed the first my lord, with your lordship.
Why NBW interim? There was interim order, no further proceeding.
Entry order
How NBW is issued?
NBW that has been challenged by the petitioner before lordship.
When the NBW was issued?
NBW, my lord. NBW issued, my lord, on that date, 9 January 2024, my lord.
If this court has stayed the proceeding,
the trial court has vacated the stay order and has
6 months after expiry of 6 months. And we have the Supreme Court.
No, the 4th July.
For that.
On 4/7/2023, this matter was taken up by the coordinate bench and passed the following order. Following order. Following order. After lapse of 6 months, the trial court took up the matter, and noting the absence of the accused persons. Where is that NBW order? Yes. Noting the absence of the accused person.
My lord, accused my lord filed the petition under section 317 CRPC. That was rejected and
the absence of accused person, and although the petitioner have moved application 317 CRPC, same was turned down and NBW was issued. Therefore, the petitioner seeks indulgence of this court. Taking into consideration the fact that this court had already issued an interim directive on 4/7/2023, inter alia, staying the further proceeding in GR case number 236 of 2021. The NBW issued by the trial court on 9/1/2024 is set aside, and the matter is stand over to second week, and the interim order passed on 4/7/2023. It continues. We'll continue till next day.
Item 11.
Yes. 11.
Item 11.
Right there.
Item 12.
Yes, 12.
May it please your lordship.
Yes.
My lord, this matter was before your lordship on the last week, my lord. This relates the petitioners before your lordship are engaged in real estate business. My lord, I am essentially particularly challenging the proceeding under Section 6 of the OPID Act.
By in the last order, you are directed
Last
to file an
order,
appeal.
your lordship, I filed a bunch of Honorable Supreme Court orders, my lord. But while your lordship was hearing, the other side, my lord, my learned friend said that another similar matter was disposed of by this honorable court, and the order was filed before your lordship. Your lordship asked me to file an affidavit on behalf of the petitioner. My lord, I have filed that affidavit at flag B, my lord. My lord, actually, the affidavit says that the petitioner number 2 is the managing director. He was in this case, my lord, he was in jail custody for 3.5 years, and he was released by the Honorable Apex Court by order dated 16/5/2023. And after a few days, this application was filed. There was no intentional suppression, my lord. It is due to lack of ignorance.
Yes.
Due to lack of ignorance and in coordination, my lord, that fact could not be instructed to his lawyer. That is we, and we did not fail to mention the matter, my lord. My lord, the petitioner too has begged unqualified and unconditional apology, and your lordship may award exemplary cost if your lordship pleases. But since all the matters are before the Honorable Apex Court, the further proceeding under OPID Act may be stayed, my lord. That's our plan, my lord.
My lord, my humble submission is that CRLMC is not maintainable in view of the order passed in CRLMC number 2497 of 1999. Earlier, your lordship has passed the exact order copy. 2497 of 19. Earlier, I have.
Where is that order?
Earlier, my lord.
जो order का देखे थे समान अर्थ रखो.
But this issue is pending there in Supreme Court.
My lord, but this CRLMC is not maintainable in view of this order. Because under Section 13 of the OPID Act stipulates the provision for appeal. My lord, your lordship may kind turn to para 7, page 8.
Page 8.
My lord.
Yes.
As it appears, in this case, the petitioner had filed CRLMC 1126/18 during the investigation of this case, which is still pending. The petitioner, without disclosing the same, much after filing of charge sheet and cognizance taken in his presence by the order dated 9/7/18, has filed this petition with the aforesaid prayer. That too has made prayer to quash the criminal prosecution in city number so and so. So also I have filed competent authority to make the attachment absolute under Section 9 of the Act in designated court. So also the complaint made before area authority. Section 13 of OPID Act speaks that any person, including the competent authority, if aggrieved by an order of the designated court, may prefer an appeal before the High Court within 13 days from the date of the order. Much after taking up cognizance and proceeding initiated against the petitioner under OPID Act, so also initiation of proceeding under Section 9 of the OPID Act. Therefore, he could not have challenged the prosecution before this court by filing application under Section 482. That is the finding. Could not challenge. Instead of preferring an appeal provided under OPID Act.
That is against the attachment, my lord.
If at all, OPID Act is attracted in this case. If it is attracted in this case, then he will resort to Section 9. He is challenging the fact that OPID Act is not attracted in this case at all. So why should he resort to the procedure given in OPID Act?
Well, that is the finding of it has not been challenged.
No,
This order has reached its finality.
No, this challenge is something different. He was asking for quashing of the entire proceeding.
Yes, Miller.
OPID Act was there. So the court says that since the OPID Act is there, you have to resort to 13 by filing an appeal. But what he says today in this petition is the OPID Act is not attracted at all in view of the judgment of the coordinate bench, which is pending in Supreme Court. So you have to await the outcome of the Supreme Court order.
Miller, that definitely, Miller. We have filed the appeal in Supreme Court.
You have challenged.
Yes, I have challenged.
In all the matters.
In the meantime, that decision has been held as per inquiry by the Supreme Court. Last time I have shown that, Miller. And para 10 of the petition in Arsenal, para 10.
Para 10.
Para 10 of the petition. Petition. Page 9.
Yes.
Today affidavit is quite false that we have no knowledge about the CRLMC. Deliberately they have not mentioned in the certificate. Para 9, 10. It is pertinent to mention here that earlier the petitioner had filed CRLMC 1126 of 18 before the Supreme Court during the investigation of the case and last withdrawn on April. And subsequently had filed a CRLMC 2497 of 19 before the Supreme Court, which was dismissed on 2/3/21. Miller, importantly then, CRL number 71119 has been filed by petitioner against the rejection order dated 8/8/19, passed in discharge petition. The LCR has been called for which is now pending before the Hon'Ble High Court of Orissa. So CRLA has been filed, the charge has been framed. There is a challenge that filed the CRLA. 6 witnesses have been examined.
That is pending.
Miller.
559.
Yes.
And filed by the petitioner against the ex parte ad interim order.
No, 711.
That is against attachment.
Miller, 711.
711?
Yes.
It is regarding charge, this charge.
Yes. Now they came up with another petition, challenge the entire proceeding and cognizance.
What is happening to the other matters insofar as OPID Act is concerned? Suppose eventually the High Court, the Supreme Court will dismiss your petition, saying and upholding the order of the single judge of this court that in these kind of cases OPID Act is not attracted, then what will happen?
Miller, that trial will be subject to the outcome of Supreme Court as held in the another case.
Which case?
That I have said, Miller, in this case. That is the subject to result of 6 witnesses have been examined.
How many witnesses are there in this case?
The total number.
Other this parenchyrium, they say.
Well. Merely because the application is pending before the Supreme Court, all the proceeding will be stayed. In all the cases, this.
Yes, Mr. Patnaik, what the prosecutor says, since you have resorted to many remedies and you
Sir,
not
that has
disclosed,
been withdrawn, my lord.
you are admitting the fact. Admitting the fact that you have really not disclosed those things. And the fact that the witnesses are being examined.
9 witnesses have been examined.
What he says is, let the trial proceed, and the trial is subject to outcome of the proceeding before Supreme Court. This has been an order in one of the matters by the coordinate bench, which says that the order of the single judge saying that OPID Act is not impacted is
Your Lordship would kindly see, all other orders have been, the interim stay has been.
No, not a single case.
Yes, my
I am objecting not a single case interim order.
Why are you misleading, Mr.? I have filed my lord.
No.
I have filed my lord all these orders.
Any case? A single
I have
case.
given you copy.
No. You come to page 1 minute. Page the first judge order of this court is Justice Panigrai's judgment.
Yes.
Ends at page 21. Just see.
That once they have not served.
No,
That
no,
decision.
petition
Yes,
copy.
yes, we have served it, served you.
21. 21 is affidavit.
And thereafter 21. No, not in the petition, the bunch. And thereafter the first order is Rasmita Patra.
Yes, that is under challenge before the Supreme Court.
And Supreme Court, it's pending.
Miller.
And thereafter, again, Supreme Court order in Rasmita Patra, in
Dayamanti Naik.
Dayananti Naik.
Yes, my
And
lord.
thereafter in Nivedita Das.
Yes, my lord.
Nivedita Das delivered along with the Rasmita Patra.
Nivedita Das. And thereafter, again, another matter in Nivedita Das.
Nivedita Das, that Miller the judgment delivered along with Rasmita Patra.
Jagat Jivan Naik.
This petition.
My lord, this is
No
the
implement.
petitioner. That is the bail application. He got the bail. Yes.
And what
my lord.
about bail application? This is bail application.
If a lordship will see these two judgment which has not been taken up by the single judge, Honorable Justice Panigrai, the parties were same. Cognizance order has been confirmed and the charge has been confirmed. Thereafter, Honorable Single Judge passed the order which is under challenge. That CRLA 32 and CRLA. Parties are same. Rasmita Patra, Prasanna Patra.
No, that is stayed in the Supreme Court.
No. That is earlier decision for inquiry. This Honorable Court held that these two decisions have not been.
No,
taken.
that is Domburdur Mudali.
In that case, they hold that.
Dushmanta Kumar Mudali.
Yes, my lord. In this case, the Honorable Court hold that these two decisions has not been taken care of.
Okay.
Yes, my lord. In this case, in that case, parties are same. Rasmita Patra and
Acha, what the
yes.
court says, insofar as Justice Panigrai's judgment is stated to be per incuriam because these two judgments are not taken care of.
Miller, parties
So
are same.
therefore, the court says that it's subject to outcome.
Yes.
You face.
Miller.
And that judgment is pending consideration before Supreme Court. How many matters are pending in Supreme Court now?
My lord, nearly 6 matters, my lord, already.
6 matters, sir.
I have given you your lordship the copies, my lord. 6 matters, my lord.
That criminal appeal and earlier CRLMs. Parties are same. EPS
How
case same.
how many witnesses are there in this case?
That
64.
64 witnesses, my lord.
How many witnesses are examined?
9.
9, my lord, are being examined.
How many you want to examine? Not all, no?
No. We are showing the many witnesses because of the
Why I will be
every
prejudiced, my lord? Since the matters are pending, read large before the Honorable Apex Court. You
No,
yourself have gone,
The only
my
problem
lord, they
is
have
this.
gone to the Honorable Apex Court, taking a chance, my
No,
lord.
that's right. But how will you deal with this judgment of our own High Court saying that the judgment of Justice Panigrai is per incuriam? How will you deal
My
with
lord,
it?
can I only say that in the same circumstances, as the entire matter are before the Honorable Supreme Court, they can hesitate this case also, that per incurium judgment has been passed.
Is this Dushmanta Kumar Mudali is pending in Supreme Court?
No.
Have you checked it up?
Yes, ma'am.
Dushmanta
They will
Kumar
state-
Mudali.
Let them say that in the Supreme Court, my lord. But why
No.
all will be prejudiced, my lord? Suppose ultimately.
Dushmanta Kumar Mudali is not taken to Supreme Court.
Yes, I know, my lord. That is not there in the orders, my lord. What I am submitting, my lord, let them state this thing before the Honorable Apex Court. Since the matters are pending before the Honorable Apex Court, I indulge your lordship's judicial consciousness and elasticity, my lord, for giving relief to the parties, my lord. Otherwise,
You have
will be.
have you filed a written submission?
My lord, I have not filed. I will file one.
My lord, for
You file a written
IA
submission, you also file, give all the judgments as possible.
My lord, for the time being, stay may be.
All the judgment along with
Miller.
the list of.
Miller.
I am reserving the judgment. You file.
Miller.
And
My
deal
lord,
with
can
the
I pray
Justice
for-
R.K. Patnaik. Deal with Justice R.K. Patnaik's judgment where he says that it's per incurium.
All right, my lord.
My lord, let them solve that copy, my lord, that per incurium they have not given us the copies. Judgment copies.
He will be filing his written statement, a written argument along with the judgment, and he'll give a copy to you. Thereafter, you file.
Yes, my lord.
All right.
So that
Yes, my lord.
you can deal with it.
My
Prepare
lord,
and file.
can,
Keep a copy.
my lord, a date may be
Yes.
fixed till that date. This proceedings may be
Judgment
stayed.
may
my
roll
lord.
out.
Within a week, the parties to file their written submission along with relied upon judgments within 10 days hence. 10 days. 5 days, within 5 days you give and so that.
Miller, within 5 days.
Okay.
My lord, may I pray till that period stay may be granted, my lord? My lord, otherwise I will be
Judgment trigger
prejudiced,
was
my
please.
lord. My lord,
No,
otherwise
judgment
I
I
will
have
be
written.
prejudiced.
Judgment I am reserving. I passed.
Yes, my lord.
Okay. Yes. Next.
Item 30.
May I please, Judge? The
Yeah.
present petitioner who is assailing the issuance of the notice under section 15 of the Payment of Wages Act, which has been initiated on behalf of the opposite part number 1 and 2. You'll also may kindly see the annexure 1, page 8.
8, huh?
Page 8 of my brief.
Okay.
Thereafter, your lordship may come to page 31, annexure 3.
No, page 8, huh?
My lord, page 8.
Next.
The very initiation of the complaint petition
One
before
minute, 1 minute. Let me complete it. This is item
13.
1 3. 1 3. Okay. 1 3. Yes. Page 8. Okay.
The complaint which has been initiated against the present petition.
Where are you reading?
Page 8, annexure 1. Complaint is opposite part number 1 and 2 before your lordship, and they are the complaint before the learning code.
Rasmita Naik
And Sri Biren Kumar Jena against the employer, that is Kurpa Sindhu Ghana, who is the petitioner before your lordship.
Yes.
That is of the case under section, my lord, 15 of the Payment of Wages Act. Your lordship straight to come to page 12 of my brief. The case has been presented on 17/7/2019.
12.
17/7/2019. Then your lordship may can see, after issuance of the notice, I filed the WS. That is much relevant.
7/19.
17/7/2019. It can suffice the everything from my so-cause, the written so-cause, which has been filed before the learned court below. Your lordship straight to come to paragraph 6 of page 31, annexure 3. The present complainant claiming the Payment of Wages Act.
This is your so-called.
My lord.
Para
6.
Okay.
It will suffice in that. That's so.
So
also, institution of this case by the complainant is bad in the eyes of law in view of section 15(2) of the Payment of Wages Act, which provides that every application shall be presented within 12 months from the date on which the deduction of wages was made. And in this case, the petitioner has filed the case for relation of arrear wages for the period of covering from November 2016 to December 2017. And such, the complaint petition is not to be filed within December 2018. That is the barrier which has been envisaged under section 15(2) of the Payment of Wages Act.
How much?
1 year, within 1 year.
How much? What is the amount?
Amount they have calculated, that is 42,000.
What are you running? What do you have?
That is a subject means industry, very little, small scale industry.
You are an industrialist, they are workmen. Why don't you pay?
No, to that extent, my lord is correct. I have so sympathy towards the firm. That the
Filing
complainant.
from
But
2019.
where is the document that they have employed under me? And that apart, even the accepting for a moment, my lord. What is the statute say so?
Where have you said that they're not working?
That is I have written my name. Contractual basics, I have mentioned.
The very fact that you are saying that they should have
They are
filed,
contractual basics and they have been removed.
you have said that they should have filed in December, but they filed in January.
No, January
July.
no.
December 2018 they should have filed,
My lord.
but they have filed on July 2019.
19.
So
After-
therefore it is barred.
Barred.
That's what I say.
My lord.
The very fact that you are saying that they should have filed means they were working with you.
My lord.
So why 42,000 rupees? Why are you not paying unnecessary?
My
were
lord,
working
as per
under
the-
you.
as per ନାଇଁ ସେମାନଙ୍କ prayer ତ ବହୁତ ଗୁଡିଏ ଅଛି
They might have spent more than what
ନାଇଁ,
they are going to get out of this.
ସେମାନଙ୍କର ଗୋଟେ prayer ହଉଛି 42,000 ଆଉ ଗୋଟେ prayer ହଉଛି 39,000 ଆଉ ଗୋଟେ prayer ହଉଛି 81,000 ସବୁ ତ କ୍ଲବ ଅପ୍ କରିଦେଇଛନ୍ତି ଗୋଟେ କେସରେ
I can only issue notice letter. Notice has been issued?
No, yes, sir.
Well, let us see issue notice letter. Issue notice. Returnable within 2 weeks. You file it, let us.
Said till that date no judgment, stay further proceed.
What is this? Why small amount you are asking for stay?
Because statutory provision saying so that
Let them come, you come with some money, you pay and finish that.
within 12 months from the date of allegation.
Maybe.
That is 15.2 is clearly mentioned, madam.
But that's right, but the amount is very small. If you pay something, they may drop the case.
Asunto say
Asunto,
till that date no course of action. That much, madam. I do oblige, madam. I have some sympathy towards the MP.
Workman matter no stay.
A specific date.
So what will they do? Nothing.
Your lordship has the vast experience regarding the payment of OJS Act. I know that what they are doing.
Nothing serious is going to happen.
Say till that date, madam.
Give date sorted date. First week. Second week.
15th March.
Mr. Das submits that he would be moving application before trial court for adjournment. He may do so. He may do so owing to the fact that the matter is of jurisdiction before this court.
Obligation. Adjourn.
Maybe. Order of cognizance is under challenge, my lord. And the basis of implication is co-accused statement. That was my content, specific contention, and my lord has also kind enough to direct the state to examine this aspect. If, and it is also my contention for the contention, if 7 accept anything, say, well, the best, rather than the co-accused statement is there, I have no case.
What is the offense?
379. Allegation is there, my lord. Some persons.
Oh, 379.
Some persons tried to take
In that
away.
case, my lord,
In
the petitioner also filed a anticipated bail application, my lord, that has been rejected with direction to appear before the court below.
379.
My lord. And my lord, in this case, my lord,
What have you
Again,
taken?
pardon?
What have you taken?
Nothing has been taken.
iron plate.
Offense has also not
Iron
also.
plate.
Offense has also not been completed. As per the prosecution case, some persons who are the allegedly employee, they tried to take away some iron plates worth about 90,000 in a truck. Perhaps that is the allegation. And in that particular allegation, it has also been held that on the way, the truck was breakdown, for which it was not materialized. And the things that the iron plates was as it is inside the premises. And when a supervising authority, so the higher authority,
Attempt to theft. Kind of.
yes.
What is your rule?
Well, my role, 7 except I was an employee, and because of this some interest dispute between the employees, my lord, I have been implicated. So that's why my humble submission from the very beginning that 7 accepts the allegation of co-accusation. If something is there, I have no case.
So that's what last time he argued.
My lord.
What are the other materials except co-accused statement?
Except co-accused statement, my lord, another witness, my lord, named Nabin Meher. ମୋର ନାମ ନବୀନ ମେହେର ପିଲା ସତ ମୁଁ ଶ୍ୟାମ ଟେନାଲିକ୍ସ ରେ କଣ୍ଟ୍ରାକ୍ଟର ଭାବେ ପାଉଁଶ ବୋହିବା ପାଇଁ ଠିକା ନେଇଛି। ମୋ ପାଖରେ ଆମ ପଡ଼ାର ଅନିଲ ମେହେର ମୋର ହାୱା ଟ୍ରକ୍ ଯାହାର ନମ୍ବର 77 ପାଉଁଶ ବୋହିବା ପାଇଁ ଗତ 19/1/2022 ପର୍ଯ୍ୟନ୍ତ ଲାଗିଥିଲା। 19/1/2022 ଦିନ ଅନିଲ ମେହେର, ତାର ଡ୍ରାଇଭର ଅଜୟ ବାରିକ, ସିକ୍ୟୁରିଟି ମ୍ୟାନେଜର ସୁଶାନ୍ତ ରାଉତ, ସିକ୍ୟୁରିଟି ସୁପରଭାଇଜର ଲକ୍ଷ୍ମୀନାଥ ବେହେରା, ମାନସ କୁମାର ମଲ୍ଲିକ, ମଳୟ ସ୍ୱାଇଁ ଦି ପିଟିସନର ଜଗନ୍ନାଥ ମହାନ୍ତି ମିଶି କମ୍ପାନୀ ଭିତରେ ଆଇରନ୍ ପ୍ଲେଟ୍ ଚୋରି କରି ଗାଡ଼ିରେ ଉକ୍ତ ହାୱା ଟ୍ରକରେ ଆଇରନ୍ ପ୍ଲେଟ୍ ଲୋଡ୍ କରି ତା ଉପରେ ପାଉଁଶ ଲୋଡ୍ କରି ନେଉଥିବା ବେଳେ ଅନିଲ ମେହେରର ଗାଡ଼ି ନିଶାନ ଭଙ୍ଗା ରେଲୱେ ଫାଟକ ପାଖରେ ଖରାପ ହୋଇ ଠିଆ ହୋଇଥିଲା। ଆଇରନ୍ ପ୍ଲେଟ୍ ରାସ୍ତାରେ ପଡ଼ିଥିବାରୁ ଉକ୍ତ ଗାଡ଼ି ୱିଟନେସ୍ ଜଣେ କହିଛନ୍ତି।
यार कौन नॉलेज था से गाड़ी रो
ତାର ଗାଡ଼ି ମାଲିକ ଗାଡ଼ି ନେଇକି
neither he has
and other persons were arrested and charge sheet submitted against them.
that's why my submission
This is one witness have said.
Married. Other witnesses are there, married. The co-accused also co-accused persons are there. And Pradeep Mukherjee also another witness, my lord. He is not an accused. He also stated. Malay Swai, Pita Malay Swai, Thana number.
The truck was found inside the premises.
No. Near the railway fatak.
that is inside
Another.
no don't confuse
It is coach, brother. ଗତ ଡ୍ରାଇଭର ଅଜୟ ବାରିକ, ସୁଶାନ୍ତ ବାରିକ ମିଳିମିଶି କମ୍ପାନୀ ଭିତରେ ଆଇରନ୍ ପ୍ଲେଟ୍ ଚୋରି କରି ଗାଡ଼ିରେ ଉକ୍ତ ହାୱା ଟ୍ରକରେ ଆଇରନ୍ ପ୍ଲେଟ୍ ଲୋଡ୍ କରି ତା ଉପରେ ପାଉଁଶ ଲୋଡ୍ ନେଉଥିବା ବେଳେ ଅନିଲ ମେହେରର ଗାଡ଼ି ନିଶାବାଙ୍ଗା ଠାରେ ଆଉ ରେଲୱେ ଫାଟକ ପାଖରେ ଖରାପ ହୋଇ ଠିଆ ହେଇଥିବା ଆଇରନ୍ ପ୍ଲେଟ୍ ରାସ୍ତାରେ ପଡ଼ିଯିବାରୁ ଉକ୍ତ ଗାଡ଼ିକୁ ରେଙ୍ଗାଲି ଥାନା ପୋଲିସ ଜବତ କରିବାକୁ
after that we it is there I am such and in security department Siam Materials Forger Limited Rengali such and such would like to bring you notice that today, that is on such and such, at about 5:30 a.m. during regular checking of
outgoing
fly ash vehicle on the way towards our ass dumper. So it is inside. And always checking by the authorities made only inside their premises, not outside.
Axe dump, eta bahar hai.
No, not
premises bahar. Se coach railway phata pakhare.
Inside, what see?
In fact, there are other accused persons. They have been arrested, my lord. They have custody and they are later on they are released on bail, my lord. This is my lord. The based on that, my lord,
he is on bail.
No, my lord. He is shown as absconder, and for that anticipatory absence rejected. And direction given to him approach before the court below. And without carried the order of this on the court, they have again filed the for passing of the. There are prime facie case made out, my lord. The other
charge sheet is filed.
Charge sheet is filed, my lord.
The same person, the informant statement, my lord. I am Sushant Kumar Raut, such and such. Aji company ଲାଗିଥିବା ଏକ ହାଇୱା ନମ୍ବର such and such 500 ଲୋଡ୍ ହୋଇଛି ଆଜି ସକାଳ 8ଟା ବେଳକୁ ରୋଡ ନମ୍ବର such and such
ସମସ୍ତେ କହିଛନ୍ତି
ଆଣି ଡମ୍ପିଂ ଏରିଆକୁ ଯାଉଥିବା ବେଳେ ଡମ୍ପିଂ ଏରିଆ ଇଜ ଅଲୱେଜ ଇନସାଇଡ ମାଇ ଲର୍ଡ ଡମ୍ପିଂ ଏରିଆକୁ ଯାଉଥିବା ବେଳେ ନିଶାନ ଜଙ୍ଗା ରେଲୱେ ଫାଟକ ପାଖରେ ଗାଡ଼ିଟି ସ୍ପ୍ରିଙ୍ଗର ପଟା ଉଲ୍ଟି ଯିବାରୁ ବ୍ରେକଡାଉନ ହୋଇଥିଲା। ଉକ୍ତ ଗାଡ଼ିଟି ଆମ କମ୍ପାନୀର କଣ୍ଟ୍ରାକ୍ଟ ନମ୍ବର such and such ଅଧୀନରେ ଚାଲୁଅଛି। ଉକ୍ତ ଗାଡ଼ିର ମାଲିକ ଅନିଲ ମେହେର ଯାହାର ଘର ରାମନଗର ନଗର, ଗାଡ଼ିର ଡ୍ରାଇଭର ଅଜୟ ବାରିକଙ୍କ ସହ ଚୁରୁପାଲି ଉକ୍ତ ଗାଡ଼ିକୁ ନେଇ ଲଗାଇ ସେମାନେ ଠିକ କରୁଥିଲେ। ଆମେ ପେଟ୍ରୋଲିଂ କରୁଥିବା ସମୟରେ so petrolling is always inside the vehicle.
And there are allegations, my lord, they taken.
Where is anticipatory bail rejected? Why anticipatory bail?
Not rejected, my lord. The honorable court, while disposing, said it is open to the petitioner. Yes, it is open to the petitioner.
Copy.
Also, there is
I will end the allegations. Court, while not inclined to grant anticipatory, directed that the petitioner, if so choose, may surrender before the court. Appropriate order according to the law. Paragraph 6, my lord.
He would have got the bail, he would have never come in there.
Exactly.
And I try to find out a way to give him
and so far
leeway so that he will come out.
And
your lordship may stay. Your lordship may stay.
Are filed after.
Since co-accused person, all the co-accused person will resume bail, my lord.
I will pass a no coercive action. You go and appear and get it.
And other co-accused person are religious, that relevance of consider.
Because there are evidence.
My humble submission. Merely because I have filed application for anticipatory bail, It
Na,
doesn't, my lord.
সেটা
take away my-
সেটা আমি জানি, সেটা তাপ দাও।
And so, but
But you say except co-accused statement, there is
No,
nothing.
my lord.
But he is reading.
No, no, no.
some
Name
which-
board.
My lord, what he's placing, my lord, the statement of the owner of the vehicle
Huh.
who has no knowledge. My lord, may see. Where
সেটা এই সময় করা ছুটি না হবে। আর details.
my humble submission, while attending the case of 482, I would also see the veracity of the particular statement of a particular person under what circumstances he has said, whether he is
At this stage.
statement, whether he is eyewitness, and what is the source of information.
Eyewitness story,
He has
eyewitness
said, I being the owner, and this information what he gathered from the co-accused.
I'll take that submission also. I'll take care of that. Don't worry. You, I'll protect you.
without-
I'll protect you.
May-
Go.
may-
I'll protect you. And according to me, with due respect, you are straight away entitled for bail.
Obliged for that.
Due respect.
But my lord, I am.
And what I'll do is, I will protect you and go and appear in the court and argue all these points at the time of framing up.
Exactly.
Both the things are taken care of.
When I am with all my effort before this honorable court, although I am not I will be not the counsel, but whatever the petitioner's effort, while making argument in the quaternary application, also in 482 application, failed to my lord say. My lord, I'm sorry, I can boldly say failed. So how can I whatever endeavor will be made in the lower court, I will be
But I think I'll take care of that.
my humble service, I can take the example of this Jamraj, who my lord has Jamraj has said Putravati Bhava. But yes, because there the Savitri has said that because of the fact that my lord is saying on this one hand, Jamraj is saying on the one hand Putravati Bhava. But unless and until my husband will be alive, how can I get this up? So my humble effort in this honorable court, by exercising that particular
Shall I record all this thing and dispose?
No. My humble service, my manager say without efforting or surrender religion bail. And this part also.
Wait, I'm giving little more than what you are expecting. Please. They'll also agree. Because this is a case where you should have got.
Honorable court, 379 in a case of theft, it is the judgment of the honorable court. Bail, not jail, will be the rule.
Well, in custody.
No.
When there is no circumstances, there is no other circumstances.
The fact remains,
My lord.
they were attempting to do it. They could not take it. It is basically 379 attempt.
511 attempt.
So in that case, if you
And this Ramesh Kumar judgment squarely covers to my interest, man.
କଣ ଗୋଟେ ହବ ତାହେଲେ
It must be said.
କେତେ ସମୟ କେତେ ଏକ୍ସାମ୍ପଲ ଦେଲେ
And this
example
ବହୁତ କଥା କହିସାରିଲି
I think I have given a tried my best, my lord.
The petitioner has filed the present petition invoking the inherent jurisdiction of this court, seeking quashing of the cognizance order. The order of cognizance dated 4/5/2022 passed in TR case number so-and-so. Whereby the learned court below has taken cognizance of offence under section 379 IPC against the petitioner. The petitioner.
379 120B 408.
Main to we. Mr. Chand, learned counsel appearing for the petitioner states that except the statement of the co-accused, there is no material whatsoever available on record, which will justify the prosecution against the petition. Per contra, Mr. So-and-so appearing for so-and-so points out that apart from the statement of the co-accused, one of the witness,
Owner of the vehicle.
one of the witness that the owner of the vehicle has also
Nabin Meher, madam.
Owner of the vehicle, namely
Nabin Meher.
Namely Mr. Nabin Meher, has also deposed against the petition. However, the fact remains that the allegation against the petitioner is that the petitioner, along with the other co-accused persons, were trying to theft iron. What is that? Iron
Plates.
Iron plates on the factory premises. By loading it in a truck owned by mayor.
Covered by us.
Which mayor?
Navin Meher.
Owned by one Mr. Navin Bear.
Who is the owner of the vehicle?
The stolen items place were covered by acts. It is illuminating from record that the stolen articles could not be taken by the accused persons as the vehicle in which they were attempting to take away the stolen articles was broken in the effective remand. Therefore, Mr. Chand submits that this is not even a case under 379, 379 because the petitioner and the co-accused persons did not succeed in carrying out the theft. Mr. The present petitioner had earlier approved this court by filing ABPL number 5348 of 2023, seeking pre-arrest bail. However, he did not get favor from the court. Rather, the coordinate bench of this court has directed the petitioner to appear before the court below and seek appropriate remedy. Next question. The case is at a cognizant stage. So therefore, it would be appropriate for the petitioner to raise all the points at the appropriate stage of the trial. To that extent, the petitioner, Mr. Chand, submits that the liberty may be granted to him. To raise all the points before the court below. In the meantime, the petitioner seeks to comply the order dated 7/7/2023 passed by the coordinate bench in ABUPM number so. Let him do so. Therefore, Mr. Chand seeks protection from this court. But taking into consideration the peculiar facts of the present case, I am of the considered view that the petitioner should appear before the court below on or before 30th of March. I'll give little more time or 30th March.
7th of March.
7th of April.
13th of March.
30th of March 2024 to avail his remedy under law as permitted by the coordinate bench. Till then, he shall not be. Till then, no course of action should be taken. No, I have protected you. I have recorded everything.
The moment I will appear, my lord, because the fact
I have recorded everything.
My lord,
It's a case of causing that everything I have written.
I don't like for that. I am obliged for that, but things remember the result will be one and the same. Again the Jammu.
Am I sitting in appeal over this order? This order is staring on the face of record. What can I do?
No, my lord, I said if so desire. Basically, if so desire, it's not a direction.
You have expressed and you are desire to go. That's what I have written. And I am protecting you till then. I can give you further more time. 30th March I have given. I give little more try. Till then nobody will arrest. You go and surrender and get an order.
Deposit.
Huh?
Deposit.
No. Already in.
He's saying that take a direct order and give.
No.
And this honorable court,
that will be unfair to
the. This honorable court also in several occasions, my friend was also there. If your honorable court also saying on surrender release on bail, that is order. The honorable court.
This I will not. This is the practice.
It is to be adopted.
It's very dangerous practice.
No, if this court feels it, right?
No, then I think whatever the permissible limit within 482, I'm doing that. I'm not going one step beyond that. If there would not have been a order of a coordinate bench, I would have done it. If some bench is not giving, I'm diluting that order under 482, then it is a conflict.
My lord, may I add one line?
We should have
It is-
little discipline.
Sorry. My lord, may I add one line? It is submitted that co-accused persons have been granted bail.
Then
The land
Mr.
court will-
Chand further submits that all the co-accused persons have already been granted bail. So therefore, he is otherwise entitled for the relief on parity. And the ground of parity, he can very well raise this ground of parity before the court. What else you need? Okay. Within the limitation of Yes.
May I please also? Challenging
Which
the
item?
cognizance order dated 1/9/2016, my lord.
Yes.
Challenging cognizance order dated 1/9/2022, page 27, annex 3, my lord. The allegation made in
Speak little louder. Little louder.
I can do it. My lord, the petitioner challenging the cognizance order dated 1/9/2022 by page 27, annex 3, my lord.
Yes.
Allegation made in the FIR is that opposite party number 2 married to the present person number 1 on date 11/3/2009.
Have you settled the dispute? You want to settle?
Want to settle
The matrimonial dispute,
matrimonial dispute, my lord.
498A, 323 and all.
13/2/23.
I will issue notice to explore the possibility of settlement. Okay. Opposite party number 2. Issue notice to opposite party number 2.
No coercive action, my lord.
Are you on bail? 498 what? You will get bail. What is
Bail,
What is it?
cognizance.
You are already on bail.
My lord.
What no coercive action? That is a cognizance stage. Leave first, second week or third week so that you serve. We'll see. Okay.
Item 19 date 19.
19 Mr. Pondankar case.
Conduct mentioned
yes.
matter for a
Yes.
the date just has to be fixed.
Date we have already fixed. Huh?
5 तारीख ना
29th. Huh?
5/3 ना कौन
Next Tuesday.
5th.
है date.
No. So another submission was there. The lower court photocopy of the lower court record be called for. That is their submission.
The scanned copies of the
Scanned
lower court records may be called for.
Order
That's
sheet.
all it is.
Order sheet.
On behalf of Mr. Devashish Panda. What is your name, ma'am?
Ayushi Mehta, my lords.
Aishu Mehta appearing on behalf of Devashish Panda for the petitioners seeks time. Seeks an adjournment. Seeks an adjournment. And submits that the proceeding before court below
My lords.
may be entire proceeding before court below may be why for you need
No, they need
Order
scan copy of the order sheet.
Order sheets
Why-
of
why
the
do
learned
you
court
need
because, my lords. My lords, because it has been submitted, the main contention here is that the charge sheet has
Okay,
been submitted
okay.
without the chemical examination
Okay.
report.
The scan copy of the entire proceeding of the court below may be called for. So as to ascertain as to whether the chemical
Examination report.
examination report has already been placed on record or not. And in what manner the said document is introduced. Full stop. The court below is directed to place on record. इधर पुलिस ने डायरेक्ट दरकार डायरेक्ट to place on
Registered.
record,
Registered.
My registry may be directed to after.
Yes.
It's fixing the date to
12th.
Mr. How appearing another case? That is 12th.
5th one.
12th.
Right of say the time got 12. Yes.
Item number 16, my lord,
Obliged.
requisite filed within 3 days, my lord.
Yes, you file.
My lord.
My lord, may I please, Your Honor? Item number 47, my lord. Item number 47.
I'm not taking up any mentioning. When it will come up, you tell. Wait. What is this?
Yes.
May I please?
Yes.
My lord, the present petitioner filed an application under section 311 to recall the PW witness, my lord. So, my lord.
311.
My lord, yes, my lord. That has been rejected, my lord. So, my humble submission is before the lordship, my lord. The lordship may can call for 5 number of witness out of 8, my lord.
Huh?
Oh, the
We again that's
not
sufficient.
bargaining. PW2 only.
Only
Think
PW2.
over.
My lord,
Otherwise, I'll dismiss
my
it.
lord, PW1 is the complainant, my lord.
No.
ଆପଣ ଚୁଜ୍ କରିନାହାନ୍ତି କାହାକୁ ଡାକିବେ କୁହନ୍ତୁ?
So PW2, doctor.
ଡକ୍ଟରଟା ହିଁ ସଫିସିଏଣ୍ଟ.
My lord, all are the medical staff.
No. You can't ask for retrial by calling everybody. Why have you not cross-examined? For what good reason?
My lord, some cost may can impose and.
No.
Cost ତ definitely impose ହବ.
Judicial time is taken like this.
My lord.
ରିଟ୍ରାଏଲ ହେଲା ଭଳିଆ ଆଉ ସମସ୍ତଙ୍କୁ ତ ଡାକିବ।
ये item କେତେ ଥିଲା ଏଟା?
ଏଟା ହଉଛି
23.
23.
23 तक मैं लिखी तो लोगों लिखी दियो 23 and later give me the file. I'll conclude it. Okay. 23 done. Yes, next.
No, 3%.
ସେମାନେ ସେ କଷ୍ଟଟା ବିୟର କରିବେ ଯୋଉ ୱିଟନେସ ଟା ଆସିବ।
हाँ, you will be.
So at least my lord 3 may can.
ସମସ୍ତଙ୍କୁ କେମିତି ହବ ଆସେସମେଣ୍ଟ କରୁଛ?
No, out of 8 my lord 3 my lord.
Next item.
ରିଟ୍ରାଏଲ କରିବ ନା?
May I please, my lord. The petitioner challenging the order dated 16/9/23 passed by the London Trial Court who issued warrant of attachment, my lord. Case is the NA Act, my lord. The petitioner is the accused, my lord, and the London Trial Court imposed 20% as per provision of 143A of NA Act, imposed 20%, my lord, and that will come 1,50,000. The petitioner unable to pay, and thereafter the London Trial Court issued issue of warrant of attachment, my lord.
What is wrong in it?
That is not wrong, but the petitioner now unable to pay, my lord.
So unable to pay is something different.
Yes, my lord.
What is wrong in it?
No,
That is the statutory
wrong is not there.
statutory requirement. You have to pay.
Yes, my lord.
Then what to do? If there is any illegality or infirmity, then I can interfere. Otherwise, how can I interfere?
Issue warrant of attachment, that is the legal.
Obviously, it has to be recovered by
Recovered
land revenue. You tell me, will you deposit? Yeah. Subject to deposit the amount, I will pay. Simple. Yes, you deposit.
Notice issue. Notice may be issued to the opposite.
There is no point issuing notice. Unless you deposit. 1,50,000 rupees.
I will take instruction, my lord, after 1 week, my lord.
Better I will say it.
Yes, ma'am.
Subject to this payment of the amount.
Installment.
That is the requirement. You have not asked for installment also.
Fixed in installment, my lord. In 5 installment, I will pay.
It is up to 40 to 20%. You only NI.
Up to 20%.
Up to 20%.
Up to or 20.
No, up to 20%.
Up to.
Up to.
Up to then 50% कर दो.
हाँ 50% कर लीजिए चलिए वैसे 2 लाख टका खंड देगी जा दो नहीं 50 तो 50 देगी जा
Not exceeding the 20%.
Not exceeding.
Not exceeding 20.
Not exceeding.
So up to 20.
Up to 20%.
The petitioner is challenging the order dated. Where is that order?
16/9/23, page 13, my lord. Page 13. 1-3. 16/9/23.
Order dated 16/9/2023. Page 12.
Page 13. 1-3, my lord. 13.
whereby the execution petition filed by the opposite party public complaint under section 143 NIX for execution of order dated 18/10/2022 has been allowed. And what is attached? Accused we are not paid interim compensation, then what is the warrant? What is the attached?
This is directed to send the IIC all and warrant of attachment for sale, my lord. Last line.
What is what? Sale of what?
That machine, harvester machine, my lord.
Which one? Where is it?
In the petition,
Where is form 43?
Or not 43.
Form 43 CRPC.
What? See the order. What is it written? Attachment of what?
That machine, the question machine is the.
Where from I will get it from the record?
My lord, page 8, my lord. Page 8 with the complaint petition, paragraph 2, my lord.
8.
Yes, my lord. Paragraph 2. The accused negotiated with the complainant for purchase of a harvester and cost of rupees 99,50,000. That is the machine in question, and that for that purpose the check has been issued, my lord.
You have to tell form 43 has to be filed. You have to struggle a lot to understand what exactly you want. Attachment of what? Nothing is there in record. Whether it is a property attached, your house is attached, or your machine is attached, you have to everything in a speculation. I have to pass an order on the basis of speculation. How can it be possible? Has been allowed. Has been allowed. The petitioner the petitioner is directed to pay 1,50,000 rupees. 1,50,000 in persons to 1,58,000 interim compensation, being the 20% of the check amount. Check amount. The petitioner contends that he is not financially capable to meet with the financially capable of to comply the same order. Issue notice to the opposite party number 2, returnable within 3 weeks, subject to the petitioner depositing 75,000 rupees. The order dated order dated 16/9/2023 passed by which court? Passed by which court? Passed by JMFC.
Yes, ma'am. Lord JMFC Soro.
Soro in ICC case number 28 of 2021. He states. Date the
Pardon, madam, 50,000, ma'am.
No, 75. You have filed a petition without having any particulars. Still, I am giving interest. This order. Okay, next. 45.
May it please your lordship.
Yes.
My lords, the petitioners have approached this honorable court for quashing of the cognizance order dated 31/12/2022, which is in Annexure 8, page 50. For offences under 498A, 294, 323, 501, 506.
498A.
Yes, your lordship.
Lordship, last occasion, Lordship directed me to verify actually what relief can be given to the petitioner if the conduct of the victim is so, then scrutinize the record.
Yes.
I have verified the record, so it appears, but since I am from the prosecution, I cannot say so. You Lordship may issue notice to the victim.
Stay.
Yes. Let her to appear.
Because the conduct, I
Yes.
believe.
Yes.
Earlier also she filed or something.
Only because of that. Only because of that.
Issue notice to the, I have to write something while giving this. What was the case?
Yes, Your Lordship.
496.
So for quashing of cognizance order dated 31/12/2022 for offences under section 498, 294, 323.
It's all right, you tell me.
My Lord.
Legality facts.
So, my Lord, the case is that the complaint is alleging, complainant is.
I paid for quite the order of
Okay, it's all right. You are on bail.
Yes, I was on bail, my lord.
Give me the date. When you got
On 1st of November 2022, as per the direction of the Honorable Orissa High Court in BL Appeal number 10006.
First number. It's all right. First number 2022, NBW 26 December 2022, and C15 and 500. Okay, 500. Cost 500. Cost. Okay, next. 48.
May I please, Your Lordship? My Lord, the petitioner is an innocent husband, my Lord.
All husbands are innocent.
All my Lord.
Right.
My Lord.
According to you. According to you. Yes.
My Lord. My Lord, marriage held at 2013, my Lord. After 13 years after, my Lord, she filed a.
What are you asking for? NBW?
My Lord. My Lord.
What the NBW? What?
Was on surrender before the.
Huh?
Surrender.
Surrender.
Surrender illegal bail, my Lord.
You are on bail?
No, my Lord. No.
Anticipatory bail filed, it was rejected. Serious allegation was there. So it was rejected. Certificate has not been given in this application.
Okay.
And now absconder NBW issued. So yes.
I'll keep it in evidence. Let him go and appear.
Yes.
Go and appear. I'll keep it in evidence.
My Lord, appear on religion bail, my Lord.
What are you talking? You know?
My Lord.
482. I'll release on bail. I will keep it in evidence. You tell me the date. I will give that date. Go and appear and take release.
My Lord.
How much time you want? You tell me. That much I can give you.
Within 1 month, my Lord.
30th
March.
April. Sorry,
30th March.
Right down. The petitioner is seeking passing of order dated 6/9/2022, passed by JMFC Raulkala, whereby Raulkala in GR case number 510 of 2022, whereby NBW has been issued against the petition. Mr. Maharaja, appearing for the state, submit that the petitioner's anticipatory bail application was rejected. He has been an absconder. Therefore, the NBW has been issued. Next, the land counsel for the petitioner on instruction from his client submits that he would appear before the court below on or before 30th of March 2024 and seek remedy available to him under law. Till then, he seeks next, taking into consideration the aforementioned submission made at the bar, the NBW, the order of NBW dated execution of order of NBW dated 6/9/2022 passed by JMFC Raulkala in GR case number so is kept in events till 31st March. So as to enable the petitioner to avail his remedy under law.
Oblige, my Lord.
You can go and appear.
Oblige.
Okay. Raulkala hi likhai chahe. I can't help it. That's the whole difficulty. You corrected now. Okay. Bhubaneswar, I have made.
Much grateful, Lord.
Counter sign. Counter sign.
हाँ कर दिया.
And see, check it up with the other places also. In
My
the
Lord.
main prayer also.
Yes, my Lord.
You have said the same thing.
In the main भुवनेश्वर लिखा हुआ है.
Bhubaneswar.
हाँ तो मैं check कर
Just check it up.
देती
And in the front page also.
मैंने देखा उसमें भुवनेश्वर था.
Pardon, my
Page
Lord.
also you might have taken.
Pardon, my Lord. Rural Raulkala.
Rural Raulkala.
ମୁଁ ତ ସେଇ କଥା କହୁଛି.
Be careful you are while saying that.
My Lord.
I may please, Lord.
Yes.
My lord, NI Act proceeding 205 was allowed, but the petitioner could not attend the court. For that, NBW has an issue.
Go and appear now.
NBW has an issue, so that may be.
Request कर देंगे NBW.
केवे इतला
22/9/2017.
On 2017.
17.
What is the check amount?
Check amount ମୁଁ ବି ଆଉ ଦେଖିଲିନି.
On 22/9/2017, the court of NGN come JMFC Tangi
Yes.
ସେ କିଛି ଲେଖିନା.
passed the order had issued NBW against the petitioner in ICC case number 27/4/2015. Okay. The case is the petitioner is facing the prosecution at the instance of opposite party under section 138 NIA. Due to his consistent absent, the NBW is issued. Learned counsel for the petitioner
Condition violated.
Condition
violated.
Consistently on instruction submits that he would his client would be appearing before the trial court on or before 15th of March and seek the remedy available to him under law. Next subject to on the submission and circumstances. The order dated 22/9/2017 passed by so is satisfied, subject to petitioner appearing before the court on or before 15th of March and paying a cost of rupees 1,000 to High Court Bar Association. Right?
Yes.
51. Yes.
51.
The perhaps opposite party filed an I for modification order, but copy not served. I am the petitioner also.
51. Now 51. It no modification. Modification 52.
Sorry.
Juvraj Mahale. Adjourned. Chalo, come to 51. 51 only.
Yes, sir.
51 be modification.
More copy they WhatsApp. I am appearing for the
Copy. Let it be. You are for opposite party.
I am for petitioner also.
Let it be.
Chetan
Yes.
And then IA for modification of the order. Lordship directed to surrender before the relevant court below and released on bail. That part has been omitted because the fact is given.
What? Which one?
52.
Order.
No. Order which order?
Order date order date.
Order 8/2/2024. Here, the warrant was issued prior submission of the charge sheet, and we moved before this court and this court.
Show me the order which you want. You want
the order
8/2/2024,
What happened?
In this case, the warrant was issued before submission of the charge sheet. And we granted anticipatory bail by this honorable court. Thereafter, I have annexed the order under Annex 3.
What do you want? You have to go and appear and tell all these things. What is wrong in it?
Wrong matter will be sent into custody because.
Then what can I do? You have to take remedy and.
No, I have been granted anticipatory bail, madam.
Let's go and tell that court. It was only for a cancellation of NBW. I say that you go and appear and tell all these things. I have kept it in the device. What is wrong in it? Why should I?
Because 304.
You want a cancellation of NBW? I'll cancel it and grant you bail also. What is this?
Because the anticipatory bail was granted.
You go and tell that court. That is what you have to tell the court. If anticipatory bail was granted, you have to go and tell that court that wrongly you have issued the NBW and
that NBW was issued prior to order passed by this honorable court in granting anticipatory bail. That I am submitting.
What have I said in this?
Submission संपूर्ण भूल करनी जो दिमागी order है. because of his mistake, my lord,
Which
this order
part
has
is
been passed.
saying?
Because he could not able to draw the attention of this court that he has been granted bail.
Already enlarged on bail. Yes, that's what I'm saying. Para 3.
Debating on a constitutional standard already.
What is wrong in it? I don't understand.
Already on bail.
That enlarged on bail, that means that granted anticipatory bail, my lord.
Whatever, you are already on bail. That's what I'm saying.
Yes.
What is wrong in it?
Say part my lord may indicate.
No. The orders are not for your satisfaction. Or I have recorded that you are already on bail. And NBW is issued, it is quashed and go and appear before that court. And
That paragraph 3, my lord. Paragraph 3, my lord, however, they could not appear in the court below on 6/3/2020. No, my lord.
NBWs are issued if you don't appear.
That 6/3/2020 during the course of the investigation.
Say that upon say Chetal case policy observation
that problem. You order a problem. You appear. That is what I said. Go and appear. Forget about small problem. What is the big deal about it?
He may send to custody, my lord. This is the
that is because if you are not entitled, you will be sent.
No, I am entitled. I am entitled because I
have the NBW. How will you send the if you are on anticipatory bail? No court is going to send you like this. Anticipatory bail, you are there already.
But the Lord Magistrate will.
Oh, you are apprehending that he may do it. You read his mind sitting in the home. He is unnecessary apprehending.
Bail will lekha in place of where your lordship
the petitioner has moved this application for modification of order dated 28/2/2024. He points out that in para number 3, in the para number 3, it is recorded that the petitioner could not appear before court below on 6/3/2022, leading to issuance of NBW against them. In what do you want to say?
Your lordship may kindly insert. He has already been enlarged on anticipatory bail.
In APLPL number that.
Therefore, he wants modification of the said order because this observation may be this observation. Just see what I'm writing.
Yes.
Tomorrow again you will move an application.
No, sorry.
This observation may be misconstrued by the court below. Therefore, he wants a clarification. Let Constable the petitioner submits that his clients were on already enlarged on already availed the pre-arrest bail on
by the order dated 27/8/2020, passed in ABLPL number 6237 of 2020. Annex of 3 is the order I have annexed. Annex of 3 I have annexed.
He has placed that order as an annexure. 3.
Page 50.
Then and the you want that that should be taken that should be a part of the order.
No, only that.
On the basis of this observation, the application stands allowed. And the order dated 8/2/2024 is modified accordingly.
Yes.
Lordship directed
unnecessary you are apprehending so many.
Lordship directed to appear on or before 29/2/2024 may be extended to
2020.
29/2/2024.
29/2 you go and appear. No.
29
timing. Yes. These applications are unnecessary applications. Anyways. Yes.
May I please, your lordship?
Yes.
Petitioner has filed an application under section 9, subsection 2 of the Juvenile Justice Act. Under annexure 5. Stating therein that I am the juvenile. The determination has not been made in view of section 15 of the Act, read with 94 and 103. So also the relying upon that judgments also in the paragraph, your lordship on the page 32 and 33.
Rule 12.
Yes.
Yes.
And in respect of that also one judgment has been quoted there. But the learned trial court has rejected by the annexer 6 at page 34. The operative person at page 35.
Read 35. What is the reason?
Yes. Prior to that, may permitted.
36. Considering the submission above.
Yes.
I have. Yes.
Lord, considering the submission above made.
Yes, I read it.
I have gone through.
What is your case? I read it.
Yes. My humble submission is that juvenile has been defined in the act itself, less than 18 years. Juvenile conflicts in law is also less than 18 years. The order, as I have annexed about the determination of the juvenile, there is no psychological test has been made. However, he has sent to treated as section 5 being a heinous offense.
In the investigation, what have you found?
And no, it is investigation has already been over, charge sheet is submitted.
That's
Trial
what I'm
has
saying. Investigation, how have you ascertained the age of the girl?
Exactly, Lord.
Yes.
And
Let us see.
Sir, let me complete.
If
Sir,
it is
let me complete.
within the parameter of 12, then you are
Within the parameter of 15, not 12. 12 is for less than
Rule 12.
section 15.
Rule 12, just let us see. I
Yes.
understand.
But the preliminary
2015 Act, not that is 2021 Act.
see, ठीक है,
No,
see,
that is
your lordship
2015
kindly
Act.
turn to
You
page
tell me the material, that's all. We need not go into all this thing.
page 26.
20?
26.
Okay.
This is the JJ board. This court has assessed the age. They provide that for such assessment from that, my lord, order dated 9/6/2017. Para 1, 2, 3, 4. Provided that for such an assessment, the board may take the assistance of an experienced psychologist or psychosocial worker or other experts. Right, my lord? And accordingly, the board come to a conclusion by taking the assistance of these experts that the person, this child, is not at all a child. He can understood everything. He knows the consequence of the act he has committed. That is the assessment hold as per section 15 of the Juvenile Justice Act. So there is no 164 statement has been recorded.
It says that the child is 16 years of old.
Yes.
The board
Yes.
says
Yes.
the material physical capacity of the
Yes.
child conflict with law, CCL.
Yes.
To commit such offense and ability to understand the consequence of the offenses,
Exactly.
so and so, asking him to the question so and so, so and so. Yes.
So board has already come to the conclusion. Then there is no other
team complete.
Yes, he completed. Yes.
Your lordship, may kindly see that page 27.
20?
27. What
Yes.
my friend has said.
Yes, I am
The
27.
prime principal magistrate has recorded that he has able to understand the consequence. Your lordship, may kindly see the proviso of section 15. Provided that such assessment, the board may take assistance of experienced psychologist or psychosocial workers or other experts. The findings prior to that 9/6 order. 9/6 order does not show anything. Your lordship, may kindly see the 9/6 order at page 19. Sorry, as page 19, kindly see for a moment. Dated 26/4/2017.
Here.
Page 19.
Just see.
Yes. Child in conflict in law is present
in the court. Board
before this board today, along with the father
preliminary assessment as per section 15 of
15
OCJ
and put up on 6/5/17 for
full
orders.
today.
Is done in full today.
Yes, I am reading that, sir. Why you are interfering? Is done in full today. Put up on 6/5/2017 for orders. And the proviso, so also the section 15. Section 15 says in case of heinous offense, alleged to have been committed by a child who has completed or is above age of 16 years. The board shall conduct a preliminary assessment with regard to his mental and physical capacity to commit such offense. ability to understand the consequence of the offense and circumstances in which he allegedly committed the offense and may pass.
What is your
My
case?
lord, my case is that the learned court has rejected my application that when the case is posted for argument, there cannot be any assessment of juvenility or determination. The Honorable Supreme Court says at any moment, even if at the trial,
Which is the, but this assessment has already been done.
assessment has been done, keeping that without taking
And
the
after the
assistance.
assessment is done, you move in another application, which is rejected, obviously.
No, my lord, I may be sorry to say. My entire endeavor is that if assessment had been done under section 15 proviso and the explanation to or the proviso of the
What is
subsection
this order? 9/6/2017
No,
order.
9617, I am not challenging that order. I am challenging the order dated 14/12.
Juvenile Justice Board preliminary assessment order.
Yes,
That is there on record.
that is on record.
But then on the face of this order of Juvenile Justice Board, how would you say that the
My lord, these, they have treated that,
Annexure 7 is wrong?
may I submit to you?
Hmm.
They have admitted I am less than 18 years, more than 16 years.
Yes, that's an
Then definitely under subsection 33 of section 2, I am a juvenile. I am not challenging that.
The
But
proviso,
fact remains,
but the proviso.
but the proviso
But for the
and,
proviso you are put to.
and subsequently, they refer the same to the court as if I am an adult. And I have tried, faced the trial as if an adult. The trial has already been concluded. The Honorable Supreme Court says, even if trial has been concluded,
That's there. There is no anytime
if
in the
there is no confusion,
in the second appeal or in the Supreme
or
Court of
whatever it may
you
be,
can do it. That's not
wherever it may be.
Huh.
But my question is that when you have not assessed me in view of section 15, read
The
in section
assessment-
94 too.
9/6/2017 assessment has been done by board.
Your Lordship can say board means that does not a single person. Board comprising the psychologist.
Have you challenged this order 9/6/2017?
No, I have not challenged that.
Then
So what left?
Then the question, your Lordship kindly see.
you allowed this document, the assessment of the JJ board, Cuttack, to remain on the record. How will you get out of it?
But if the court has treated me as juvenile, then the punishment is to be imposed by the juvenile board, not by the court.
That is, you argue on sentence court.
My lord,
Court who is awarding sentence.
because your Lordship kindly see the court has passed the order. What the court has passed the order.
But that will be in appeal, not in 482. I am only examining whether there was an appropriate assessment
Your
by
Lordship, your
under
Lordship,
section 15
page
proviso to section 15.
Page 36 and 37 mechanism.
Yes.
If the court will sit over as if I am an adult, then definitely the punishment under the IPC so also under the POCSO Act is to be applied. Ignoring the power conferred under section 18 of the Judge Act. Because the punishment has been provided under section 18.
The first time it is coming.
The first time.
4 o'clock. I'll just issue notice, let us examine it.
My lord.
Your Lordship rightly pointed out the question that why you have not objected.
That is gone on record, then nobody can help it.
That is also.
I am not saying that.
No, he has some legal issue we wanted to point out. Let us understand.
Point out.
Okay. Oh, first week we put up to the first week, second week, second week.
Last week, my lord, because the
Second week. See,
I am not claiming stay for the timing.
Second week I'll try to. Second week at the top.
Can I pray if necessity I will sort for adjournment?
Yes. No. Before that it may not be possible. That's the whole difference. Because
Yes, my lord, I am not saying, but if necessary, I will take adjournment before the learning trial.
okay, 14 later.
Well, also observe that if necessary, I am not saying that it is.
You, if necessary, you come and mention.
Yes,
I'll take it up. Don't
yes, I will.
Anytime you
obliged,
are
my
welcome.
lord.
Anytime you
Yes.
are welcome here. Yes.
Request the
Yes. What type? What?
Item 59, a compromise matter is there.
I
all have
I
come.
think I can take only compromise. matter.
Yes,
My lords, with your
Sorry,
lordships,
sir.
the lordship's kind permission, may I mention there is an item 55.
Yes.
That is I'm passing for the income tax prosecution for not depositing the tax deducted at source in time. Since there is
What
less
was the delay?
delay was, I have paid the tax with interest. Yeah, it was neutral, revenue was neutral. But the lordship knows about
Generally, I
270.
quash all these things. Wastage of time of court.
Well,
I'm generally quash it. Leave a sorted to quash.
well, 55.
Roll over, it will come tomorrow.
My lord, 56.
Tomorrow.
Yes,
In next
The
item.
which I will not take up today will come up tomorrow.
No.
Did not mention.
My lord, so far 56 is concerned.
In item number, my lord.
My lord, legality come on Monday.
My lord, I have objection.
I have been
I
instructed.
have objection.
You may object.
No, he has
Go on
a
objecting. You go on objecting.
Your lordship may kindly see the last order. They were to direct to whether they will withdraw that 133 proceeding after disposal of be giving a certificate given by the municipality. I went to the office. I showed the order.
I don't remember, but he.
I don't dispute that. Everything I am accepting. Your lordship directed me to take instruction. Some personal difficulties there. That is why I am praying
In
to
the
take
bar,
instruction.
you have to.
That is, I am not disputing your submission.
You
I am
tell me.
accepting this.
You tell me which date you want, so that.
Friday, my lord.
Friday.
Monday take a can I have been instructed on Monday, lordship.
ଆଜ୍ଞା ସେ withdraw କରିବେନି ସେମାନେ ମତେ କହିଲେ ଅଫିସ ରେ ଯେ ଯେତେ ପର୍ଯ୍ୟନ୍ତ ହାଇକୋର୍ଟ କ୍ୱେଶ୍ଚନ କରିବେ ଆମେ withdraw
ମୁଁ
କରିବୁ
ସେ କଥା ନାହିଁ ସେ କଣ
I can file an affidavit.
ମୋର instruction
My client is here. I
Don't
can
worry,
file an
he has
affidavit.
to give me the instruction.
Exactly. I have to give
Don't worry,
instruction.
let it be on Monday.
Your lordship has already formulated the point and decided it. You asked it was a formal order.
Okay.
I don't dispute
Monday will
everything.
be most auspicious for you.
I am
My
accepting.
lord, every day is auspicious for me.
Let's treat Monday because he has a personal problem.
Yes, that is why I
He
am.
should be accommodating to the personal problem.
In item number 24.
Monday.
Do you have any problem? Monday.
My lord, I was praying for Friday.
Friday is not there.
वो से ସେଥିପାଇଁ ଖାଲି ଗୋଟେ
Thursday,
problem
ମାନେ-
ଅଛି ବୋଲି।
Thursday?
ଗୋଟେ only Monday your lordship may kindly so that your lordship I am to satisfy your lordship. I have to get instruction now. I am
What about tomorrow? All matters, spillover matter will be taken up tomorrow.
only Monday your lordship. Only one matter I am praying from Monday. Nothing else. All matters tomorrow. Only one matter Monday. I am praying. That is my personal difficulty.
My lord, here my lord, I am not opposing his adjournment.
Yeah, let it come tomorrow, and tomorrow you make that. Because today he is in a mood to oppose you only. Tomorrow he will not oppose.
Pardon to mention, my lord.
What I will be opposing for?
Pardon to mention, my lord. Item
Let it be on Monday, my lord. Let him
you don't
not take
oppose.
any further adjournment. That much your lordship may say.
My lord, item 56, it may,
56.
my lord, 56, I am for the Jagannath temple.
56 Monday. No further adjournment will be given.
Yes.
And item 56, I am for the opposite bid number 3. On behalf of Subra Satpathy, may kindly be taken on Monday because he is,
Monday, I'm saying.
No further adjournment will be given. I am indicating. Okay.
Item number 54, there is a noting in the cause list that the notice is delivered, not served. So in that
Lordship,
case, I may be permitted to serve the notice through special messenger by tomorrow.
Lordship, I have appealed opposite party, my lord.
He is appeared already.
Directed to
Let
be
it come
copies.
tomorrow. Let it come tomorrow. Next.
Okay.
Yes.
Item
65, permitted to withdraw.
Permitted to withdraw.
Item 59, matter has been compromised,
All
case,
madam,
counter
madam,
cases.
It will come tomorrow. Don't worry.
Item 61, one at a time.
61 adjourned.
My lord, item 63, I wanted to file my Vinama on behalf of opinion number 2.
It will be taken up tomorrow, sir.
Tomorrow.
All the matter will be taken up. Only
Compromise
the
matter.
matter where it is compromised, parties have come. I don't want that the people should keep on coming to the court.
Adjourn 61.
Item 59, case, counter cases. Case, counter case, my lord, both are came together, my lord. Now the matter has been compromised, affidavit has already been filed.
Yes. What is the offense?
Offense, my lord,
Okay.
tribunal magistrate.
Counter case.
Counter next case, my lord.
Counter case. 59 na?
Again.
What is the offense there?
Offenses, my lord, 41.
Hey, tribal estate.
What are the allegation?
Allegation is that there is a push and pull. There both are neighbor. There is a dispute, push and pull, and FIR has been
Yes.
lodged against each other.
Yes. Okay.
Aye.
First one, right.
Also file affidavit.
First one,
My lord,
right.
that 56,
First one, right.
56 interim order to continue.
Entry order continue.
Yes.
First one, write down. At the instance of the opposite.
Opposite party number
opposite
two.
party number 2, FIR number so and so came to be registered against the petitions. Came to be registered against the petitions. The allegation charge sheet filed.
Yes, yes. I am challenging the cognizance order.
Not filed anything. What cognizance? File करोगे तो पता चलेगा ना.
Cognizance order.
Not
5/5/2022. First. That is,
neither charge sheet, nothing.
yes, 3877. I have
Charge sheet
ଟା ଅଛି ମୋ ପାଖରେ ଯେ।
ରଖିଥାନ୍ତୁ ଆପଣ conviction ହେଲା ପରେ କରିବେ. File କରିବେ.
Hey, your lordship, turn to annexure 2, page
What
11.
is the allegation I wanted to see?
FIR allegation, my lord, at page 8.
Okay. I am so sorry to tell that there is no assistance. Everything has to be done by the court.
Charge sheet,
I am very sorry.
earlier it has filed that.
Even if indulgence
Achi,
is
achi.
given, no assistance.
Charge sheet don't. Photo
Kuch bhi utha ke file kar देते.
Only give the charge sheet.
Correction
That's
कुछ
what.
भी नहीं.
Charge sheet put. ये certificate को दे दियो. Certificate दे दो so that it will remain kept in the court record.
हाँ दे दियो, कर दे।
Detail काट दो. Detail
चार्ज शीट दे दो।
दे दो.
ठीक है.
But charge sheet certificate को भी kept in the record. Both the cases.
ये देखो. Where is the affidavit?
Affidavit, I have supplied, my lord. Affidavit টা दे दियो।
Record. Affidavit. The petitioners and the opposite party and the petitioners have settled the dispute and they filed the affidavits. Opposite party number 2 has filed the affidavit. Who is the opposite party number 2? Opposite party number 2 has filed an affidavit, entry stating that he has settled the dispute. File Priyadashini Patra.
Yes.
Just ask Mr. Goda. He settled the dispute and she doesn't want to settle the dispute on the intervention of the village entry and well-wishers. He doesn't want to proceed with the criminal case against the petitioner. The opposite party number 2. Where are the petitioners?
Petitioner.
Arjun, who are the student? That's why Lordship has entered and filed this pass an order to grant them bail. Lordship may see the order passed by the third court. Education. Affidavit already filed. Lordship, informant himself was present in the last occasion. That has been reflected to Lordship's order.
So what is this?
I have bail. Bail to delay. Locally Kali Kiso. Upon order pile ଆପଣ ପିଲାଙ୍କର ଏକ୍ସାମ ସେଟା ଦେଲେ ହଜୁ ଆଉ ସେ ବି ଆସିଥିଲା ତାକୁ ପୁଲିସ ଏତେ ଟର୍ଚର କଲା ଆଉ ଆସିବାକୁ ଆଜି ଲାଗେ ଆଉ ଫୋନ ବି ଦଉନି ତାଙ୍କ ଆଡଭୋକେଟ ବି ଅଛି that has been recorded by your lords ସେ ନିଜେ ଆସି ଷ୍ଟେଟମେଣ୍ଟ ଦେଲା ଷ୍ଟୁଡେଣ୍ଟ ଗୁଡା ତାଙ୍କ ଆମ ପିଲାଙ୍କର ଏକ୍ସାମ ସାର୍ I have given the schedule of the examination କହିଥିଲୁ ବେଲ
This is in custody.
Yes. Student ତାପରେ ହଜୁର ମୋ ପାଖରେ ସେ ଆଡମିଟ କଲା ମୁଁ ମୋ ପଇସା ପାଇଗଲି
No, that's right, but he is in custody. How can you pass?
Lordship can pass, my lords. I can give the
bail.
Behavior of
That is what I told you. Get some judgment where I can.
Yes,
that if you say that it's settlement
in Pokso case below. Pokso.
No, that's not an issue, sir.
Yes.
If you say
I will give. If this honorable court has passed that procedure tomorrow, I can.
Tomorrow.
Yes.
Tomorrow.
And see,
My lord,
idea is,
how dare, my lord, after getting.
I know, I made the observation, you were going, I called up and made the observation thinking that the student really. should
Yes,
get out.
and the time schedule, examination schedule, those who are in custody.
Tomorrow.
So,
The problem is,
My
you have
lordship
to
can
address,
quash it.
no, you have to address one problem.
My lord.
If he is in custody,
Yes.
have you made, where the complainant met him, how he has entered, because he is custody, judicial custody.
Yes, my lord.
You have settled the dispute with whom you settled this?
Exactly.
With the, my lord, with the informant, the father, my lord, father and.
No, you have to give the,
Compromise.
that is the whole difficulty. You have to.
Even if in custody, lordship has the ample power to quash the proceeding. I cite this decision tomorrow.
Yeah, you get the.
Okay.